how did it get into your system? You're an amoeba. Why do I get the feeling you're not telling me the truth? You just wanted to yell at me, didn't you? Where's his pants?
Got here on right before Christmas, and then I
Didn't the people on the airplane tell you what the temperature here was?
Would you allow me to take a test today to, like, I know I'm not dirty. I ain't using no drugs, man.
My name's not man.
Yes, sir. I'm sorry, sir, but I'm sorry, sir.
just come George is good.
And if it comes back dirty, I just leave you in there forever. So the people versus Edward, is it Dagness?
Comes over what the prosecuting attorney for the people.
And Your Honor, Joe Simon on behalf of Mr. Dagness. State your name, please.
Edward Dagness. Thank you.
All right, we are trying to work out a plea agreement in this matter. The issue is determining what the restitution number is going to be. My victim advocate has been in contact with the victim in this case. There's been issues around getting cost of potential medical bills and insurance repayments. So if we could get an adjournment on this matter, Your Honor, I will follow up immediately, try and get this to Mr. To get it to counsel as soon as possible.
And Your Honor, I'll just add one more thing. There's also a piece of discovery that I want to keep on the radar that we need to.
And I have reached out to the OIC about that. If we can get it, we will have.
All right. January 15th, 2026, 9 a.m. Bond continued. I don't have a green.
Thank you, Your Honor. Ed, if you can get one.
I don't have a green sheet for Mr. Simon.
Oh, you don't.
I don't have a green sheet. Apparently,
No.
he thinks he doesn't have to.
No.
That's.
No.
You'll address that.
Mr. Overwater was going to totally eat that bullet, Your Honor, but because that wasn't on me.
That is true.
I don't believe either one.
Happy New Year.
I don't believe either one of you. You're just covering. Court calls case of people versus Amari Harris.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Is that it for you, Mr. Simon?
Happy New Year, Your Honor.
And to you. I did not want to give you holiday greetings like the last time.
Thank you. A little hurtful.
Yes.
Good morning, Your Honor. Wendy Burnwell, P42505, on behalf of Mr. Amari Harris.
Your name, sir? Amari Harris. Thank you. All right, what are we doing?
Your Honor, we're requesting an exam. I know the last time we were in court, there were another lawyer had showed up, but we're asking for an exam.
All right.
And a co-defendant.
Does he have a co-defendant?
He does, Ms. Cruz Mena, that was just adjourned to January 8th.
Okay. But he's requesting an exam.
Your Honor, Jeremy Glick on behalf of Ms. Cruz Mena. I'm still in the courtroom. If it's relevant to the court, we'd be fine as well doing an exam if we could push that until the 15th to give us 2 weeks for some additional discovery and investigation.
So, well, the exam would be sometime that week. I don't know. I would normally be setting this for what, the 6th?
Yes.
But the 13th. So I can set exams in both of those matters for the 13th, if that will work with counsel.
That would work for us, Your Honor.
Yes,
It
yes,
would.
Judge, that would work. I'm already in court and an exam that day in front of you.
Okay, so let me take care of this one, and if you can hang on a second, Mr. Glick, and the discovery at least is complete, relatively speaking, to proceed to an exam. Would the people have their witnesses available the 13th?
I'm sorry, I apologize.
Would the people have their witnesses available January 13th?
I don't see any reason why we would not.
All right. Is it mine? Huh? Oh, we don't have a.
Correct, yeah.
Just because it's a capital. Can we try to find out what they're doing? Because I don't. Maybe we'll know by Monday, but maybe, who knows? All right. So I'll set preliminary examination on both of these cases for January 13th, 2026, 9 a.m. That's before me. That's in person, but we'll continue. And Mr. Glick, on your case, would you like your client brought out if I was setting that date, or?
No, Your Honor, I can connect with her in the jail and let her know.
All right, so waiving the appearance, I will also set preliminary examination in that matter for that same date.
Thank you very
All
much.
right, thank you, folks.
Thank you.
Thank you, Judge.
Yeah, that's correct. Court does call the case People versus Adrian Braswell.
That's it. Interlocutory Assistant Prosecuting Attorney.
Good morning, Your Honor. Chris Easthope appearing on behalf and with Adrian Braswell. Mr. Braswell, would you unmute and state your name for the record?
Adrian Braswell.
You got him?
Yeah.
Okay. All right. You're looking for an adjournment.
Yeah, there's an explanation for that. We're asking for another adjournment, Your Honor. Ask if the court would agree to set it to January 15th.
You and Simon,
What's that?
you and Simon picking your.
I'm
Go
just
ahead.
throwing out,
Okay.
I'm trying to be helpful.
Yeah.
Not obstructing. Mr. Childers and I were working on a final resolution. Obviously, he's not here today, so that's the whole point.
Okay.
No fault of Mr. Overton.
Of who? Yes, no, it's his fault. So he took the blame for Simon's, but not yours.
I'm not taking.
Never mind. I don't know.
I didn't hear the name that he said, so I think I dodged one.
January 15th, 2026, 9 a.m. bond continued.
Thank you very much. Your Honor.
Thank you. Court calls case of the People versus Jason Smith.
Represent on behalf of the people.
Good morning, Christina Saxon for Jason Smith.
Your name, sir?
Jason Smith, Your Honor.
He's waiving.
He is,
Sir, you're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
thank you.
No, you still have more to do. You waive formal reading of the
With
information.
us,
It's okay.
different for, we waive formal reading, stand mute on the charge.
Defendant having waived formal reading, standing mute to both counts. Court will enter not guilty plea. Pretrial will be set for
Well, if one thing for judgment.
January 12th, 2026, 1:30. Judge Hamud.
Thank you, Your Honor.
Thank you. Bond continued. Yes. Court calls case People versus Ian Nessel. Nielsen.
Hello, I'm Ian Nielsen.
Ashley Phelps for the people.
Edward Drukas on behalf of Ian Nielsen.
You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference, January 15th, 2026, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Thanks, John.
Court does call the case People versus Christopher Thaxton.
Ready, Your Honor. Interlocutory Assistant Prosecuting Attorney for the people.
Morning, Your Honor. James Fifelski appearing on behalf of Mr. Thaxton, who is on his way out, I'm sure.
And
I mean, honestly, we're not, because they're so behind to get not updating, because it's just.
so wait, you got it.
Name. Chris, that's
Thank you.
Your Honor, we're asking for one more adjournment for discovery, some outstanding records we're both trying to get our hands on.
That's correct, Your Honor. I've turned over a report that I received today from the OIC. There are medical records, defenses asking for that we don't have. I don't know that I'll be able to get those, but we can at least get into it. If I have a release from the victim in the case, the victims.
Are you gonna be able to resolve that by the 8th, if they're medical records, or
I can hear you. I'm sorry.
are you gonna be able to resolve that by the 8th if they're medical records?
I think we'll be able to know whether or not we're going to be able to get them by then. At this point, I don't believe that we are, but
Is this the only case holding him?
Yes.
Is this the only thing holding you, sir?
Yes, sir.
January 8th, 2026, 9 a.m. bond continue.
thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Denise South.
People.
Morning, Your Honor. Attorney Ryan Rams there on behalf of myself, and stands to my right, myself, identify yourself for record, please.
Denise Self, good morning, Your Honor.
Good morning. Okay, what are we doing?
Your Honor, should be a note in the file, but if not, we're seeking an adjournment of the PCC in an effort to speak to Mr. Childers about this matter. We've just received some discovery and want to present to him that information so we can hopefully resolve this matter.
January 15th, 2026, 9 a.m. bond continue.
Thank you very much, Your Honor.
Yeah.
Have a happy New Year.
And to you. Court does call the cases of the People versus Wendy Thomas.
That's with people in all four matters.
Well, good morning, Your Honor. Sam Bernstein with and on behalf of Ms. Thomas, covering for.
I am, Your
Okay,
Honor. Thank you so much. Stephanie Cannon on the remaining matters.
all right. And what are we doing?
Your Honor, we are asking for an adjournment of this matter. As this court is aware, my client was given permission by this court to go to treatment, which we believe is basically the crux of her issue. However, she's not been released yet. I believe that's because she has a new matter and the order needs to go in that case so that she can be released.
He has a new matter.
A new old matter, yes. So it was something prior to her coming in, but we'll get an order put in that case, and I do believe she'll be able to be released to treatment.
Ma'am, state your name. I don't think you did.
Ronald Quay, Cynthia Rose Thomas.
Thank you. So the new matter, who is that before?
Is it 15th?
It's in the 15th District Court, Your Honor.
Okay, so you just have to get an order over. Okay,
So we'll do it right away.
all right. But we're just, she's either gonna be released or something's gonna happen. So
You know.
let's do January 22nd, 2026, 9 a.m. If she's released to treatment, we can move it. All right. Thank you. 22nd.
Right, sorry, thank you so much.
Court calls case People versus Jeremy Shue.
Good morning, Your Honor. Jonathan Sachs for Mr. Shue. Mr. Shue, can I ask you to introduce yourself to Judge Simpson?
Here. Pardon?
I'm here, Jeremy Shue. I gotta figure out the button.
Okay, hold on. Say your name again, so it'll light up for me.
Okay, hang on. Jeremy Shue.
All right, we'll lay the camera on you, Mr. Shue.
I'm getting there.
Yeah, I recognize your voice. I know it's you. All right. That's not a good thing if I recognize your voice, but okay. All right, what are we doing?
Thank you, Your Honor. This is a request for an adjournment. This is an unusual situation. Mr. Shue has an active interlocutory appeal in the Michigan Court of Appeals on a suppression matter in a companion case that will also dictate this case. And once that is resolved, I think we'll be able to get a resolution here, but we're asking for an adjournment for that resolution.
So there's another case he has an appeal on. And they're
That's-
hearing the appeal, or?
It's on an application for leave, so we don't know if they're
They
going to
haven't
be
decided.
hearing it.
They haven't decided as of yet.
And I have some familiarity with this. I believe that that other case originates out of Judge Washington's 14B cases. I think it's a misdemeanor matter. Is that correct, Mr. Sachs?
That is correct. It's the same series of alleged incidents from the same date. So that suppression matter would control this case as well, depending on what happens.
The people have no objection to adjourning this for that matter. I will let this court know, though, that I believe the circuit court's already denied the appeal once. So I'm not sure what's going to happen with the court of appeals.
So it came out of district court, circuit court denied, application for leave is pending before the court.
As best as I can recall from one conversation I had with APA Woods, yes, that is correct.
That's correct, Your Honor.
All right, well, why don't we do this, give an opportunity to decide. Why don't I adjourn this to January 29th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will-
2026. Thank you, Your Honor.
Yes, all right, thank you. Thank you, Mr.
Your Honor. Have a good holiday.
You do the same, sir. Court calls the case, People versus Alan Rogers.
Ready, Your Honor. Good morning, Your Honor.
Who's on this case, Mr. Haddad?
Yes.
State your appearance, sir.
Alan Rogers.
Good morning, Your Honor, and good morning to your staff. Ferris Haddad on behalf of Mr. Rogers.
All right. And are you looking to adjourn this, or what are we doing?
Yes, Your Honor, I was retained this month, so we are still in the process of discovery. I'd like to adjourn the PCC and also address Mr. Rogers' bond after that.
Is this the only thing holding him?
Yes, Your Honor, I believe so.
Probable cause conference, January 8th, 2026, 9 a.m. As to bond.
Yes, thank you, Your Honor. So, Judge, I was retained this month, actually by Mr. Rogers' employer and Mr. Rogers himself, but with the help of his employer. He does have a job waiting for him as a finisher at A&M Auto in Ypsilanti. He's been working there for several years, and they're trying to hold the job open so that they don't need to replace him. He's a valued employee there. He's a hardworking gentleman. He, Judge, also, he's been incarcerated.
I don't mean to interrupt you, counsel. I'll let you finish, but I don't think this is the only case holding him. Because he was released on a furlough. And I think I signed off on the furlough here, but I think there was another judge in circuit that had to sign off on a furlough.
Your Honor, my review of that shell does indicate this is the only matter that's currently holding.
Is it? Okay.
Remanded by this court for bond violation.
Correct. But I thought somebody else had to sign off. Maybe I've got a different case. Go ahead, counsel.
Oh, no, I appreciate it, Judge. It's always good to get to the bottom of that. My understanding is he had missed some testing after initially being placed on bond and then eventually tested positive. But I think he's been incarcerated almost 50 days now. He does have a home. He has bills to pay. He has pets at his home. He has a job that's waiting for him. I'm not sure if they were waiting for a bed to put him into inpatient. I got that information from his former attorney. But what we did was we set up at a place called Serenity Therapy Center, where he can, if the court would allow him to get out, he can report to outpatient treatment and potentially intensive outpatient treatment there, so that he can actually get treatment. He's obviously
If you work out the treatment issue with the prosecutor, I'm not gonna have a problem if he's released on a tether, but into treatment. But if I don't have treatment in place, I'm gonna deny your motion to change his bond at this point in time, given the previous history on this case.
And Judge, can that be outpatient so he can get back to work and pay some bills and make sure that he doesn't lose his home and stuff like that?
Does the prosecutor have a position on that?
Not a professional in that area. I think the people's position is that Mr. Rogers needs to complete the treatment that's recommended by the professionals. There is an offer in place that he complete to a misdemeanor use. If he completes the treatment as recommended, that offer's been outstanding for at least a month.
Is that, Counselor, are you aware if that's a treatment that's recommended for him? Is he outpatient?
I'm not aware if it's outpatient or inpatient that's been recommended, Your Honor.
Well, and his offer is contingent upon that, and he's gonna have to complete the recommended treatment, and I don't know what status that's at this point. So what I'm gonna do at this point, I'm gonna adjourn it to the 8th. I'm gonna deny your request for any change in his bond at this time. His bond will continue. If somebody gets me additional information, I'm more than willing to consider something else. But everybody's flying in the dark here at this point. So at this point, his bond will continue.
I understand, Judge, that makes sense. And are you saying that you would consider a stipulated order if the people and I work something out to that effect in the meantime?
Here's what I'm saying. Yes, I will consider that, but what I'm saying is part of his, as I'm understanding it now, his deal is that he has to complete the treatment that's recommended. I don't know what's been recommended at this point. And I would imagine that people would hold to that. If it's outpatient, then he's got to be out to do that. So I would imagine that everybody can come together and do a stipulated order. And I typically am not going to have an objection to it.
And if it's inpatient, does he have to wait?
This is really not that hard. No, go ahead. What's your next question?
Yeah, it's just a question, Judge. If it's inpatient.
I know, but I got like 1 billion people here and no, go ahead. What's your question?
No, I mean, if it's inpatient, is he awaiting a bed in community corrections? Because that's what I was, that's sort of the idea that I got from prior counsel, is that he's waiting for a bed this whole time.
He might be.
Okay.
And our jail facilitates that. If he has a bed, then they'd let me know and we'd release it, because I think there's already that order in place.
Okay. Thank you, Your Honor.
Is that it?
Yes.
Cool. Bond continued. Thank you.
Right. Happy New Year. See ya.
Court calls case, People versus Anthony Alfaro Callejas.
I spelled this for people.
Attorney Zach Bonham on behalf of Mr. Alfaro Callejas, who's joining us by Zoom. Please unmute yourself and identify yourself for the record.
Anthony Alfaro Callejas.
Okay, very good. Thank you.
Yeah.
What are we doing?
Your Honor, we had an outstanding discovery issue that has been resolved as of yesterday evening. There was a video that was sent over from the prosecutor's office we couldn't access. My staff was able to get it visible yesterday. I need time to go over that with my client, and we have outstanding negotiating going on for a plea offer. So I would just ask this be reset for another PCC, and I would request for January 22nd.
No. Why are you requesting a date?
Because I heard
January. Joe Simon?
I heard January 15th being used quite a bit, and I have a conflict that morning. So I figured I'd get out in front of it.
Oh, he was getting out in front of it. That typically doesn't work.
Attempting
yeah,
to.
that doesn't work. It was a nice try, though.
Did my best.
January 29th, will that work?
Yes, Your Honor, that'll work.
I knew it would. January 29th, 2026, without objection. 9 a.m. bond will continue.
Thank you, Your Honor. Happy New Year.
And to you, sir. Court calls the case, People versus Rivas Andrews.
Prosecuting attorney for the people.
Assistant Public Defender Ben Dunwood for Mr. Andrews, who is joining me at the podium now. Mr. Andrews, would you please state your name for the record?
Rivas Andrews. Thank you.
And Your Honor, I believe Mr. Andrews would like to waive his exam. If that's true, sir, would you sign your name right there?
Is that a correct statement, sir?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
Okay, you understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
That's right.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 2, 3 with 4 following.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for.
January 14th at 1:30 before Judge Conlon.
You said 14th.
Yeah.
January 14th, 2026, 1:30, Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Yes. Court calls the case of the people versus John Brooks.
Senator Water, assistant prosecuting attorney for the people.
Good morning, Your Honor. Michael Vincent on behalf of John Brooks. State your name for the judge.
John Austin Brooks Senior. Yeah.
Thank you. What are we doing?
We are adjourning this. We have some discovery, some videos that I've informed will receive shortly.
He's toxic.
You know.
All right, I can go to the 29th or if I could squeeze you down to 15th. Which one works?
29th, that's Your Honor.
Does it? Probable cause conference will be adjourned January 29th, 2026, 9 a.m. Bond continue.
Thank you. Stay in contact.
Court calls the case of the people versus Jeffrey Moore.
Good morning, Your Honor. Special Assistant Attorney General Mitchell Wood for the people.
And
Mr. House, Nicholas Bukovich on behalf of Mr. Moore. Mr. Moore, can you please state your name for the record?
Jeffrey Edward Moore.
All right, thank you. All right, what are we doing?
Mr. Butkovich. Judge, Mr. Butkovich and I had a discussion this morning, and I'm stipulating to a slight reduction in his bond. His arrearage is actually lower now than it was when the AG issued the warrant. So I'm stipulating to a reduction to $5,375, Your Honor. That's 1/4 of his current arrearage, consistent with the statute.
All right, so 5275.
5375 is what I showed, Judge.
5375.
Yes.
Okay. And that's correct, counsel. You're stipulating to that.
Yes, Your Honor, we'll be stipulating to that bond reduction. I was also going to still address bond when appropriate.
You want to address bond? I thought you guys did. Okay.
Sorry.
Go ahead.
So I do.
You request. What are we doing with the case?
We'll be waiving preliminary exam, Your Honor. I just provided Mr. Allen the waiver.
All right. Sir, is that correct?
Yes, Your Honor.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
All right. And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People do also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. S.J. arraignment, you waive formal reading, your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set
January 15th at 1:30 before Judge Slay.
January 15th, 2026, 1:30, Judge Slay. As to bond.
As to bond, yeah, I do appreciate the stipulation to modify bond to the lower amount based upon his current arrearage. I did want to address bond because my client, prior to this being charged out approximately 19 days, did make a substantial payment of $9,900, which could have been used for his bond if this could have been used for this bond at the later court date if he did not pay that amount. So I was wondering if there be any way possible that payment could be used towards his bond. I do understand that's probably unlikely.
He paid 9,000.
Yes, there was a payment on October 2nd toward the child support matter of $9,900 on October 2nd. This matter was charged out on October 21st, 19 days after after that payment was made. So one of the reasons my client does not currently have the had the bond
Paid
opposed.
9,000. This case gets charged. His bond gets set at the amount of his, or 25% of his current arrearage. But then when they look at it, his current arrearage is actually lower because of the $9,000 payment.
Yes.
So you're asking me then to reduce it more because he made the $9,000 payment, but it seems to me that that's already been taken into account by the stipulated reduction.
Yes, I understand, Your Honor.
Am I missing something?
I understood, Your Honor. I just wanted to.
Well, am I missing? I'm not missing anything. That's it, right?
Yes.
So it's already been taken into account. Motion for bond reduction denied. Bond will be set at the 5375 to be paid if that's cash, and it would be applied to the child support case. Yeah. Yep. All right. Thank you.
Thank you, Your Honor.
Thank you.
Thank you very much, Your Honor. Happy New Year to you.
Thank you, sir. Court calls the case of the people versus LaRon Moore.
Lower Water Assistant Prosecuting Attorney for the people.
One moment, Your Honor.
One moment. What, Vincent? We're waiting. He'll never make it back. It'll be 2027 by the time he walks back in here. I'll pass that matter briefly. Court does call the case people versus Daniel Cummings.
Lower Water Assistant Prosecuting Attorney for the people.
Covered on behalf of Mr. Cummings, who is being brought out now.
Take your time, Mike. I passed it. I'll call you right up next.
Mr. Cummings, please say your name for the record.
Daniel Cummings.
Thank you.
Your Honor, may we approach briefly?
Yes.
I need you to sign here. And thank you, Your Honor, for the brief bench conference. We are here today for here as well. We are here today for bond violation as well as probable cause conference. As to the bond violation, first, Mr. Cummings is going to admit he's going to plead no contest to the bond violation.
So he admits to the violation.
Yes, Judge.
Or at least does not contest the violation. All right. Okay.
And as to the underlying charge, Mr. Cummings would like to avail himself of an offer from the people. In this instance, the people will be dismissing count 1, controlled substance possession, and Mr. Cummings will be pleading guilty to an added count 2 of misdemeanor use with dismissal under 7411 upon completion.
That's the court's understanding of what's here. May I have him sworn?
Raise your right hand. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Daniel Cummings.
Sir, it's this court's understanding you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. Do you understand that?
Yes.
Understanding that, you also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Bravo or her successor in the 15th District Court. You understand that?
I understand what you're saying. I just don't understand the process, but yes, I understand. I just,
don't
So
understand what
she's not
process.
gonna be, so you're playing, so Judge Simpson is taking your plea, but Judge Valvo will be the one that sentences you because it's a different.
am I getting sentenced?
Not today, no, but by Judge Valvo.
Sir, you have a right to have
Thank you. I
the
understand.
judge taking your plea to sentence you in this case. I have your form that indicates you waived that right. And I'm just advising you that while I'm taking your plea, I would not be your sentencing judge.
Oh, okay.
If you don't want that to happen, then something
No,
else
it's
is gonna
what-
have to happen.
However it works is yes to me.
So you, but do you understand that? And you're waiving that, right?
Yes,
Okay.
that's good, right?
Yes.
You understand it?
Yes, I do.
All right, good. So understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Looking at paragraph 5, you'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, I mean, I wasn't until I came in.
Just, yes, it's yes. Yes, sir.
Okay, at the time of this offense, were you on probation?
No, when I,
At the time of this offense, were you on parole?
no,
Okay, has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no, they have not.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
Yes.
March 5th, 2025, at the location of 1620 East Medical Center Drive, City of Ann Arbor, Washington County, State of Michigan. Did you have heroin in your possession?
Yes.
Had you used it?
I did before that day, but not on that day. But yes, I've used it. Used it.
Did you?
That rings.
On or about March 5th, 2025, at that location, did you have heroin in your possession?
Yes.
Had you at some point used that heroin?
Not that day, but prior.
But around that day.
Yes, right around that day. Okay, I'm sorry.
And did you know what you were using was heroin?
Yes.
Sir, I do have to advise you that if I accept your plea, and if between the time of your plea, between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, I do, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not.
No, Judge.
And have I complied with the court rule?
You
People
have.
are satisfied, thank you.
Defense is satisfied, Judge.
Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing in this matter will be
January 20th at 9 a.m.
January 20th.
Yes.
January 20th, 2025, 9 a.m. How long has the defendant been in?
I think 24 days?
26.
26 days at this point, Judge.
They should be able to get to him relatively quick because I'm not reducing his bond until such time as they get a chance to see him. I'll hear from you, counsel.
Thank you, Judge.
On the violation, he's been in 26 days. I'm going to sentence him to 36 days. Credit 26 days. As to bond.
Thank you, Judge. So, Mr. Cummings, this is his first time with the criminal justice system. He's 59 years old with no record, no prior convictions. He's done quite a bit to get himself clean. For one, he's been in custody and clean and not using the whole time. He is on the waiting list for Dawn Farm in-jail treatment program. He was previously, before he got arrested, before he became into custody, he was trying to get into a detox program at U of M. He became addicted to opioids as a result of a lot of health problems. He had a prior prescription, but was eventually cut off, leading to his addiction. He is an Air Force veteran. He was honorably discharged in 1988. He's been married for 41 years. His wife is battling the early stages of Alzheimer's. He's got a very supportive family. His 26-year-old son is local. His parents are here in the courtroom as well, and they can help him. Your Honor, and as to getting back to his treatment, he has a number of treatment programs available to him that he is basically ready to go to. If he was released today, he would be able to go to, he's got a 7 blocks away from his house. He's got a,
I'm not gonna have any problem. So he's got to serve at least another 10 days.
Okay.
The purpose behind sentencing to that is so that 15th District Court probation can interview him, look at it, and decide on what is the best form of release. If they don't see him in those 10 days, then his bond is gonna go back to what it was previously, and he would be released.
Understood.
So,
Thank you, Judge.
is there anything else?
No, Judge, and I appreciate the opportunity to allocute for the record.
There's nothing from the people. Good. Thank you.
Thank you, Your Honor.
Motion for bond reduction denied.
Thank you, Judge.
Court calls the case of the people versus Antonio Boswell.
And good morning, Your Honor. For the record, Terry Johnson on behalf of Mr. Antonio Boswell, who is approaching and stands to my right. State your name for the record, sir.
Antonio Boswell. Thank you. All right, what are we doing?
Your Honor, I've had an opportunity to speak to my client. We're going to request our exam in this matter.
12 days out is one. The 13th, right?
13th.
Discovery is complete, correct?
I've received what they've given me, Your Honor.
Okay. And would the people have their witnesses available January 13th? Preliminary examination in person, January 13th, 2026, 9 a.m. Hold for one moment. Do we know? It'd be before 15th District Court Judge. I don't have a name.
Do I get to pick? I'm just asking.
Sure. So I can tell the others that you didn't pick that. So go ahead.
Judge Judy, Your Honor.
Nice. All right. So that's all that we have right now. And I don't know if it's appointed soon, whether they're going to be ready to go on the 13th. I have no idea.
Understand. Thank you, Your Honor.
We'll figure it out. All right, bond will continue. Thank you, sir.
You and your staff have a good day and great new year, Your Honor. Good to see you.
Same, sir. Court does call the case, people versus de jure, Bond Sanders.
And then on behalf of the people.
Oh, I was gonna call.
Stephanie Cannon on behalf of Mr. Bond Sanders. Mr. Bond Sanders, you are present. Please state your name for the record.
Bond Sanders.
And Your Honor, we are asking for a brief adjournment of this matter.
Is this the only thing holding him?
He has a hold out of your report, somebody's provided information.
So, no, Your Honor.
Good, Cam.
Your Honor, when appropriate, I'd like to address bond.
Probable cause conference will be adjourned. January 8th, 2026, 9 a.m. Bond can, yes, as the bond.
Your Honor, currently my client has no phone privileges. He understands the reasons and the whys for that. He's exceptionally apologetic. He wants to know if he can just have one phone number that he can speak with. His daughter has medical needs. She has multiple seizures. And he wants to just be able to talk to her. And if that's the only phone number the court is allowing, that's what he's asking for, just to be able to speak to his child. How old is she?
She's 2.
And Your Honor, I'm not sure they're revoked on these cases. This is his first PCC for these cases, so I'm not sure which case it's revoked on.
I would imagine it's the other case.
Thank you, Your Honor. I will try to get a request in on the other case.
Bond will continue.
Thank you. I'll come talk to you Tuesday.
All right. So, but I don't want to miss him. Got it. All right, thank you. Court recalls the case, people versus Lauren Moore.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Good morning, Your Honor. Michael Vincent on behalf of Ron Moore. Hopefully it's somewhere. Mr. Moore, state your name for the judge.
Laura Moore.
Thank you. We need a prelim exam date and we are.
So you don't want me to address, you want it,
Yeah, we want a prelim exam.
you want a preliminary exam. And discovery is complete.
I'm all set.
People have their witnesses available the 13th.
We'll do everything we can.
Preliminary examination, January 13th, 2026, 9 a.m. That's before 15th District Court Judge. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Malik Robinson. Or Malik Robinson.
Yes. People.
Good morning, Your Honor. Wendy Burnwell, P42505, on behalf of Mr. Malek Robinson, who's also on the Zoom.
Robinson, can you state your name, please?
Malik Robinson.
All right, what are we doing?
Your Honor, we're requesting an exam. You already set one for January 13th, if that date is available. Thank you.
Yeah. You're just trying to find a way to mess with me. All right, is discovery complete, counsel?
Yes, Judge.
All right, people have their witnesses available the 13th. Oh, don't say you won't, because if I move it, then Barnwell's gonna.
You can try for that date. Your Honor.
Okay. Preliminary examination, January 13th, 2026, 9 a.m. That's before me, apparently. Before me.
Thank you, Judge.
Thank you. Bond continue.
Have a good day.
You do the same. Court calls
And
case of
Happy
People
New
versus.
Year. I forgot to say Happy New Year. Sorry about that.
And Happy New Year to you too, Ms. Burnwell. Take care. Court does call the case, People State of Michigan versus, is it Mamie Sar?
Ashley Phelps for the People.
Sar?
Sister Vilo's client, he's here.
Well, I'm gonna pass it. Court calls the case of the People versus Kyle Burmeister.
Overwater, Assistant Prosecuting Attorney for the People.
Ashley here on behalf of Kyle Burmeister, who's approaching. And Your Honor, the defense is requesting an adjournment for further negotiations in this matter. I have the green sheet.
Is this the only thing holding him?
No, there are two other matters holding Mr. Burmeister at present. Apologies, I think I should have a green sheet for this. I will provide it to the court. But there's at present, he has, but both of those are probation violations in relation to this matter. So I'm requesting a brief.
And those are in circuit?
Those are in the 15th District Court.
Okay.
Yeah.
Those matters set at $10,000 and $5,000 respectively.
That's correct.
Probable cause conference then will be adjourned to January 22nd, 2025, 26, excuse me, 9 a.m. Bond continue.
Yeah.
Thank you. Court calls case People versus Timothy Palmer.
Assistant Prosecuting Attorney for the People.
Yeah, Mr. Johnson.
Yeah.
Kareem Johnson. Oh, there he is.
Good morning, may it please the Honorable Court, Kareem Johnson, on behalf of Mr. Palmer.
All right. Palmer?
He's in the hallway, Your Honor. I'm trying to text him to come in.
Which hallway? This hallway?
Yes, Your Honor, at the courthouse.
Okay. It's a long hallway. You don't see him? Nobody responded? This is Mr. Johnson's fault. Anyway, let me pass it. I'll,
Call him, Your
as
Honor.
soon as we find him, maybe we'll call it back up. Is this him? Huh? No. All right, so I'll pass it. Court calls the case, People versus Man Davis.
Prosecuting attorney for the people.
Good morning, Your Honor. Assistant Public Defender Davi Lebo, on behalf of Mr. Davis. Who stands to my right? Mr. Davis, can you tell the court your name, please, sir?
Davis.
And Your Honor, we're still having discussions about this matter. Be requesting an adjournment.
All right.
Oh, God, on adjournment.
And he's held on other things.
He is, Your Honor.
Probable cause conference, all adjourned January 22nd, 2025.
Thank you.
26, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the case People versus Carolyn Latham.
Good morning, Your Honor, to you and your staff. Attorney Maxwell Dubin, P number 86012 on behalf of Ms. Latham, who approaches and stands to my right. Please state your name for the judge.
Good morning, Carolyn Latham.
All right. Thank you. What are we doing?
Your Honor, today's the date and time set for PCC in this matter. We're asking for this to be set for preliminary exam.
Discovery is complete.
Yes, Your Honor.
And I should let the court know, there was one thing that Mr. Dugan let me know this morning he was still looking for, which was a return and tabulation of the search warrant that was done on the house. I confirmed that it had previously been sent to a different attorney that was on this case, but we didn't have an appearance with Mr. Dugan in our file. So we've gotten that now. So I hope that he'll have all of that soon. I don't know that that would be necessary for the exam, but no matter what, he'll have it today or at the end of this week.
All right. People have their witnesses available the 13th.
We'll try.
Preliminary examination in person, January 13th, 2026. 9 a.m. before 15th District Court, Judge.
If I may address bond briefly, Your Honor.
You may.
Your Honor, my client has been on a tether for the duration of this case. I'm asking this court to consider any other means of monitoring. Your Honor, my client's missed out. Excuse me?
Nothing. Go ahead.
Okay. My client's it's starting to become a financial burden on her. It's getting very expensive, of course. And I understand, and my client understands why she is on this tether monitoring. I would like to just point out that the incident in this case did happen at my client's own home. It was not at any other home but herself. So her going anywhere or traveling to other places would be kind of moot. Additionally, Your Honor, she's missed out on 2 job opportunities. We're just requesting and asking humbly, of course, if there's any other means of monitoring that this court can do aside from the tether.
Especially the shooting case, I think the fact that the defendant has any bond at all and is out is more than fair. So I'd ask the court to continue for conditions. I said I would not ask for the bond increase, but frankly, I think I fairly could, and I'm not doing that at this time.
Yeah, given the circumstance of this, I'm going to deny the request.
Understood,
She's
Your Honor.
actually privileged in having that tether on her and not being incarcerated.
We also just appreciate you hearing us out, and
right.
thank you. And I hope you guys have a happy New Year as well, because I probably won't see you before then.
Yes, very good. You too, sir. Court calls the case People versus Jessica Hess.
Assistant prosecuting attorney for the people.
Assistant Public Defender Davi Lebo, on behalf of Ms. Hess, stands to my right. Ms. Hess, can you please tell the court your name, ma'am?
Hi, Jessica Hess.
Thank you.
Thank you, Your Honor. We do have an offer in this case is contingent on Ms. Hess completing treatment. She's currently awaiting release to treatment, so be asking for an adjournment.
Are they close, do you know, or has anybody been in touch with?
I believe you've
I've
been
heard, yeah, the next, either today, possibly.
You might be released today?
Yeah.
Okay. I think what I'm gonna do in this case is I'm gonna adjourn her probable cause conference down a little bit so she can get in and to January 29th.
Thank you, Your Honor.
2026, 9 a.m. bond will continue. All right.
Thank you.
Thank you, ma'am.
Aaron.
What's that date, Judge?
Who did she, I know you couldn't hear over her. No, she heard me. That's okay. I'll let her yell. This one was the 29th.
Thank you.
Doing,
Yeah, are you okay if I do that? Your screen.
yeah, they have to let us, is there a reason?
It's for himself.
They usually have to let us know beforehand, so we figure it all out. But he was here, right? Is there? I guess that's my only question. Find it out. Court does call the case People versus Andrew Party.
People.
Morning, Your Honor. Sam Bernstein here on behalf of Mr. Party. Who's not present with me. Happy New Year's to you and your wonderful staff, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash security. That warrant will issue immediately. Court does call the cases of the people versus Jermaine Johnson.
Ashley Beltis for the people, both matters.
Assistant Public Defender Chelsea Regiles with and on behalf of Jermaine Johnson.
Jermaine Johnson.
Thank you, sir.
To adjourn both of his cases to discuss the plea offer, and I would ask to address bond.
Anything else holding?
No.
Go ahead.
Your Honor.
You want these adjourned? I'll adjourn them. Are you gonna be able to do everything you need to do by the 8th?
Yes, Your Honor.
Probable cause conference, January 8th, 2026, 9 a.m. As to bond.
Your Honor, as mentioned, these are the only things holding Mr. Johnson. He was allowed release to treatment on the 18th. He's been waiting since and has no indication of when he might be released. So we're asking you to allow him a personal bond so that he can seek inpatient treatment while out of custody. The wait time, I understand it, has been extended lately. Mr. Johnson has very little criminal history. He's been in custody for 36 days on these two cases. He has been seeking treatment. He's doing well with that. I believe he's a trustee at the jail. He has a job lined up, wants to work while out of custody, while waiting for treatment. He very much intends on doing treatment, wants to take that step towards addressing any substance abuse issues, but asks Your Honor to allow him to wait out of custody.
All right, any response from the people?
Yes, Your Honor, I do believe he had failed to appear on one of these files and then picked up a new R&O case. He's found to have a pipe on him that looks like they would be used for smoking cocaine and also ran from the officer. So I have requested the court continue to bond as currently set.
A couple of things. I'm gonna deny the request for change in bond. His bond will continue in this matter. I would also note to counsel that I believe after the fact, I don't have a date on it. Well, I do. Maybe the 18th. I believe defendant wrote me a letter.
I'm not in possession of that, Your Honor.
Not in possession of it, and they're not in possession of it. So I'm gonna deny the request, and I'll have my staff provide a copy of the communication since the court saw it. All right,
Thank you, Your Honor.
thank you.
No.
Let you finish it. Bond is denied. There's a letter.
Was sorry, it was the eighth.
Motion was on. Palmer said. Court calls case People versus John Burgine.
Ashley Beltis for the people.
Ready, Your Honor.
Your name, sir?
John Bourdine.
Judge, due to the volume of discovery in this matter, and I've talked with Ms. Phelps on this matter, is it possible to adjourn the PCC to the 29th? Happy holidays, Judge.
Getting really bold picking your dates.
Judge, you've been the kind and considerate judge you are during the holidays.
And I don't have an issue with that date, Your Honor. I will note for the court, there is a co-defendant who's also up this morning, so I'll be asking that her case goes to that same date when that case is called.
Who has
The
that?
public defender does.
Yeah, I represent, Carla Gordon and our.
Okay.
Same day? Probable cause conference, just because you're asking me to do something different, is gonna be February 5th,
Oh.
2020, 2026, 9 AM. I just wasn't letting you have your way.
That's even better. Thank you, Judge. Haven't you?
I know, I knew that. That's why I did that just for you.
You're the best.
I know. Thank you. You do the same. Court has called the case of the people versus Tamara Johnson. And I'll try to recall.
Assistant Public Defender Bendel Johnson, who's approaching now. Could you state your name for the record, Mr. Johnson?
Thank you. All right, what are we doing?
Your Honor, we did some investigation and Mr. Johnson was not satisfied with that investigation. I'd like to adjourn 2 more weeks to see if we can do further investigation.
Okay. Probable cause conference will be adjourned then to January 15th.
Thank you, Your Honor.
2026, 9 AM bond continued. Thank you. Court does call the case of the people versus Ariana Fenn. I think it is.
Overwater Assistant Prosecuting Attorney People.
Good morning, Your Honor. J. Grant Miller, P58658 on behalf of Ms. Fenn, who should be on Zoom.
I'm here.
Hey there.
My name is
All right.
Ariana Finn.
Thank you. I have before me one. I have before me in the case ending in 5254, a plea form. Is that what we're doing?
Yes, Your Honor.
And what are we doing on our other case?
I don't believe she has another case, Your Honor. She has a sister.
Oh, they're 2 different people.
The names are similar,
Got it.
Your Honor.
Okay, they were banded. Okay. All right. I have before me then on her case a plea form that indicates that she's going to be pleading guilty to the charge of retail fraud 2nd degree. Upon her successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement between the prosecutor and defendant, prosecutor probation under the Home Useful Training Act. That's the court's full understanding of it.
That is correct, Your Honor.
That is correct, Your Honor.
Ma'am, please raise your right hand.
Mommy.
Yes, you. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Ariana Finn.
All right, ma'am, it is this court's, you can put your hand down. It's this court's understanding that you are going to be pleading guilty to the charge of retail fraud 2nd degree. That's a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes, sir.
All right. You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court and or her successor. You understand that, ma'am?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Or had it signed on her behalf? You
Yes,
did?
sir.
All right, you have any questions regarding any of those rights?
No, sir.
All right, you understand that you're waiving or giving up all those rights, including your rights under paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
And also because you believe that you are indeed guilty?
Yes.
All right. On the date of October 14, 2025, at the location of 3070 Washington Avenue in the city of Ann Arbor, Washington County, state of Michigan, what do you do at Lululemon that makes you think that you're guilty?
I left the store with the items on me and didn't pay for it
I heard none of that. What did you do that makes you think that you're guilty of this offense?
because I walked out the store with the items.
All right, so you
And didn't
went
pay
into
for
the
it.
store, you picked up some items, tried to walk out of the store without paying for them?
Yes, sir.
All right. And you didn't have anybody's permission to do that, did you?
No, sir.
The store was open to the public at the time?
Yes, sir.
And are we doing this on value? And was the value in excess of $200? Of course it was. It's Lululemon.
No.
But go
sir.
ahead. Was it in excess of $200?
No, sir.
Sorry. Yes, all right. Ma'am, if I accept your plea, between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, have I complied? Well, counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not.
Defense is not, Your Honor.
And have I complied with the court rule?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
At 9 a.m. before Judge Valvo.
January 20th, 2026, 9 a.m. before Judge Valvo or her successor. Bond will continue.
Thank you, Your Honor.
Court does call the case of People versus James Lyle.
Judge Valvo, people.
Stephanie Cannon on behalf of Mr. Lyle. Mr. Lyle, when you're at the lectern, please state your name for the record.
James Lyle.
Thank you, sir.
Your Honor, we are going to request an adjournment of this matter. I do have a green sheet.
Is this the only thing holding him or?
Your Honor, I do believe this is the only, is it full? He has a parole hold, Your Honor, however.
He has a parole, okay.
Yes.
Situation is taken care of.
He's spoken with his parole agent, Your Honor, and it's his belief that if he is able to get a PR bond in this matter, they are going to be able to
when I was arraigned, the judge and the lawyer said that they put it at $100 bond for now, so I can get time credited. But I can get the PR bond if need be. Just revert back to them and they'll switch it to the PR bond. So I'm good with the PR bond if I'm still gonna.
I don't have that, but I don't know what they're gonna do if they release you because parole is gonna take you. So I'm not gonna do that.
No, I don't
Then-
want the PR bond.
then he is asking that we set it for a preliminary exam, Your Honor.
We don't want the adjournment.
No, Your Honor, he's asking for a preliminary exam.
Discovery is complete.
Yes, Your Honor.
People had their witnesses available the 13th.
We'll try for that day. Thank you, Your Honor.
Preliminary examination in person January 13th, 2026. 9 a.m. before Judge. 15th District Court Judge. Bond will continue. Does call the case People versus Amber Corpus. Yes.
Morning, Your Honor. Jay Grant Miller, P58658 on behalf of Ms. Cormos. She is still en route from Jackson. She was having some difficulty getting here this morning.
I'm sorry, Ryan, I missed it.
She is still en route from Jackson. She was having some difficulty getting here, some car troubles. She has been texting me.
What?
Chauffeur.
You have her in Zoom? But we don't, she doesn't have permission to appear busy.
That is my understanding as well, Your Honor.
I don't know why she's on Zoom. Well, when it passes, somebody better tell her how to get here, or we'll come get her.
Yes, Your Honor. Thank you, Your Honor.
Court calls case People versus Devon Reed.
Mr. Phelps for the people.
Your Honor. Brian Bowling on behalf of Mr. Reed.
Good morning. Your name, sir?
Reed.
Thank you.
Judge, I'm just asking for an adjournment to obtain some video in this matter. I speak to the prosecutor.
That's correct. We talked yesterday.
Is he held on anything else?
Yes, he is.
He is.
Yeah, multiple matters.
Multiple matters? All right, then. Any objection to going to the 29th then with him, or is that too far for?
I guess I'd prefer a sooner date if the court would be willing.
Okay, I can give you a sooner date. No, when he'll be called, January 8th.
Thanks, Judge.
We'll just squeeze him in. 9 a.m. bond continue.
He appreciates that, Judge. Thank you.
Well, he won't that day, but that's okay.
Not going anywhere. Thanks, Judge.
Court does call the case, People versus Tabitha O'Carroll.
That's over what assistant prosecutor attorney to people.
Good morning, Your Honor. Jay Grant Miller, P58658 on behalf of Ms. O'Carroll. Sorry, she was waiting outside due to the crowding. Please state your name.
Tabitha O'Carroll.
Your Honor, I've spoken with the prosecution and I just need to submit some paperwork for a no contest plea due to a memory issue for my client.
January 29th, 2025, 26, 9 a.m. bond continue.
Thank you, Your Honor.
Court calls case People versus Kevin Smith.
Mr. Phelps for the people.
How many more in custody do I have?
Assistant Public Defender Davi Leba from Mr. Smith, who stands to my right. Mr. Smith, can you tell the court your name, sir?
Kevin LaVarn Smith. Thank you. What are we doing?
Your Honor, I believe the court should have a plea form.
Plea form in front of me that indicates the defendant is going to be pleading guilty to an added count two of larceny, 200 to 1,000 to 1 year offense. Upon his successful plea to that charge, count one would be dismissed. The defendant agrees to undergo a mental health assessment, comply with all mental health treatment as ordered by probation. That's the court's full understanding of the agreement.
Thank you, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yeah.
State your name, please.
Kevin Smith. Sir, it is his court's understanding you're going to be pleading guilty to the charge of larceny, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that?
When will that be?
Well, I haven't given you the date yet. I'm just apprising you that you would be sentenced before a different judge than me.
All right,
You understand that?
yeah,
Okay, you okay with that?
I ain't got a choice.
Well,
But
you,
do
yes, you
have a
do.
choice, sir.
You absolutely have a choice. Because if I'm taking your plea, you have a right to be sentenced before the judge that's taking your plea.
Right,
All right? What I'm apprising you of, and the box is checked about the sentence judge waiver, is that you would be sentenced before Judge Perry instead of me.
I'm
Understand
fine
that?
with that.
Pardon?
I'm fine with that.
You're okay with it?
Yeah.
Okay. So understanding all of that, do you still wish to plead guilty to this charge?
Yeah,
Okay, to the charge larceny, 200 to 1,000, how do you plead?
guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
No,
Okay. You understand that you will not have a trial?
yes,
Okay. All right. And a advice of rights form was signed with your permission, is that correct?
yes, but I also gotta say that, even though I'm from a different county,
You're from a different county?
yeah, I'm from Jackson County.
Okay.
So probation, I don't know how it works.
Well, I would let that court, 15th District Court in Ann Arbor, figure that out.
All right,
All right, they might keep you and you still would be from Jackson County, but, okay?
all right.
Okay. So you signed that advice of rights form. Do you have any question, or had it signed on your behalf? Do you have any question regarding any of those rights?
No,
All right, if you look down on the podium, there's a copy of one. You understand that you're waiving the rights under paragraph 5, as well as all the rights that are on that form.
yeah,
Yes?
yes,
Okay. You understand you're giving up your right to appeal of right.
yes.
All right. Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been said here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes,
And also because you believe that you're guilty of this offense?
yes,
All right. On the date of May 14, 2025, at the location of 343 South Fifth Street, City of Ann Arbor, Washington County, State of Michigan, what'd you do at the public library that makes you think that you're guilty of this offense?
still books.
You stole books?
Yeah,
Okay, so you went into the library and you didn't check them out, you just tried to walk out without
yeah,
doing anything? All right. And you didn't have anybody's permission to take those books,
No.
did you? All right. And these books that you took, these books belong to the public library?
yes,
All right. You don't know what the value of the books you took were, do you?
no,
All right. So counsel, I would accept a higher plea to this charge unless you have information regarding the value.
No, Your Honor, I would also note there was a die cutter that was recovered from the one that was also library property. So I think the higher charge would be fine for the people.
I agree.
Okay. All right, sir, I do have to advise you that if between the time I accept your plea and the time the judge sentences you, that you commit any type of misconduct that as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
yes, sir.
All right. Counsel, you aware of any other promises, threats, or other inducements which have led to this?
Not known to defense, Your Honor.
All right, and have I complied with the court rule?
You have, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2 under the theory of the higher charge. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
30th at 8:30.
January 30th, 2026, 8:30 before Judge Perry.
Thank you, Your Honor. And may I address bond?
You may.
Thank you, Your Honor. Mr. Smith does have significant mental health issues. He's now taking medications for these. He will continue to do so if he's released. He can stay with his mother if released, and his mother has indicated to me that if he does stay with her, she would intend to keep a very close eye on him.
All right. At this point, I'm going to deny the request. I'm going to let probation at 15 see him. I'm not going to have a problem if they wish to release him.
Thank you, Your
I'm
Honor.
going to deny bond at this time. So bond will. Thank you.
Yes, unless probation recommends being released earlier.
All right. Thank you, sir. This one. Court recalls case, People versus Timothy Palmer.
Hello, Water Assistant Prosecuting Attorney to the people.
Good morning, Mayor. Please, this honorable court, Kareem Johnson, appealing on behalf of Mr. Palmer.
All right. Your name, sir?
Timothy Palmer.
All right. All right. What are we doing on this case?
Your Honor, there is a video of the incident that is missing. We're asking the court for a second PCC date so we can try and get that video from law enforcement.
All right.
That's correct, Your Honor. It's a ring camera video. I have emailed the OIC requesting that.
All right. He's out. So what I'm going to do is probable cause, I'll adjourn to January 29, 26, 9 a.m. Bond will continue.
Thank you very much, Your Honor.
All right. Thank you, sir. Court calls case, People versus Adam Adkins.
Assistant Prosecuting Attorney to the people.
Assistant Public Defender Davy Lebo, bound for Mr. Atkins, who stands to my right. Mr. Atkins, could you tell the court your name, sir?
Adam Atkins.
All right.
Thank you, Your Honor. I'd be requesting adjournment. I have not been able to reach Mr. Atkins.
January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Case, People versus Mershand Smith.
Hello, Water Assistant Prosecuting Attorney for the people.
Brian Bowling on behalf of Mr. Smith, Your Honor. And Mark, state your name for the record, please.
Marchand Smith.
Thank you.
Judge, we're asking this matter be sent for a preliminary examination.
Discovery is complete.
I believe it is, yes.
People, other witnesses available the 13th.
Yes, Your Honor.
Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Bond will continue.
Your Honor, may I address bond?
You may.
Your Honor, this is the only matter holding Mr. Smith to my knowledge. There's a $25,000 bond. He indicates to me that he is employed at Toyota and Saline, which is a very good job. He believes he will lose that job if he remains in custody any longer. Further, it's come to his knowledge that the apartment that his fiance and daughter live in Ypsilanti, that they are going to be evicted from that residence if he's not able to be the financial support for those individuals, which ultimately ties to my early argument regarding his job. He indicates to me
the
that
apartment in his name.
It is. Your
yes.
Honor.
Who's the landlord?
We just moved there. We moved out of Arbor One into this apartment.
What's the name of the apartment complex?
I can't
So
remember.
you just moved out of Arbor One. How long ago?
Like 60 days. We moved out of Arbor One into this apartment. We've been trying.
Because you were trying.
Because it was
a mess
condemned.
over there.
Yeah, it was condemned. And if we just got this apartment, Your Honor, I don't want to lose it.
Your Honor, just
okay. Have they started? It's in your name.
The apartment is in me and her name. Yes.
We don't have anything in his name.
I could try to come up with the lease or something, but if my name is on the lease with her.
You know, when you're winning, you should stop talking.
Sorry.
See, the way he reacted, thank you, sir. If attorneys would react that way, my day would be so much easier. Anything from the people?
Yes, Your Honor. Your Honor, the facts of this case, Mr. Smith was released on a DV case. It's a city prosecution out of Ypsilanti. Several hours thereafter, the police were called because he had contacted the victim's grandmother. The victim's grandmother called the police, indicated that he had told her that he was on his way over and did not care what happened. There was a no contact and a stay away order in place on the domestic violence bond. When he arrived, police had already gotten there. He was observed by the arresting officer standing outside the door. The officer asked him to stop and come and speak to him. He immediately ran. The officer had to chase him out of the building, down the street, through the snow until eventually he fell down. The officer tased him. He did not stop. Eventually, he was able to take him into custody. The people are very concerned about his refusal to follow the court's orders regarding bond, as well as his refusal to follow the orders of law enforcement.
May I respond to that? Your Honor, it's my understanding that Mr. Smith, regardless of any other calls that may have been made, was he reached out to the Ypsilanti Police Department for a civil standby or civil assist visit at that residence to obtain some items. It's my understanding he was in communication with the Ypsilanti Police Department, actually received a return call from them, telling him to go to that location. I mean, ultimately, we're here for the allegations that Mr. Overwater just stated happened once he came in contact with the police at that location. But
what happened to the underlying DV?
It's still pending. There is a personal bond on that case. I believe it was scheduled for a hearing yesterday, and nothing was changed.
So that's what I'm trying to figure out. So if the violation is for the underlying DV, he goes there, which would be a violation on that case. And where you would suspect that his bond would be denied.
Fair enough, but
his bond is not denied. He has a PR on that case. And because. All right.
And I mean, I'm not sure exactly what happened with respect to the
call. What did I tell your client?
Yeah, fair enough.
Okay. I understand the circumstances, but if there's really a safety issue with this individual and not being able to follow the orders, that needs to be taken care of in that other case. As I'm looking at this case, I think his bond is inappropriately set. I'm also, because of his Arbor One situation, I'm a little bit worried if he loses that apartment. He's probably sat in a condemned unit for a number of months. Just trying to find a way out. So what I will do is I'm going to grant the motion for bond reduction. His bond in this case will be reduced $25,000 personal recognizance bond.
Thank you. Thank you, Your Honor.
And thank you.
You're welcome, sir.
Thanks, Jeff.
All right. Don't make me regret it. Do the right thing. You hear me?
You won't, Your Honor.
All right. Take care of yourself. Court calls the case, People versus Jamie Bailey.
And Assistant Public Defendant Nicholas Buckovich on behalf, but not with Mr. Bailey.
Wait, why are you shaking your head? Wait, hold on a minute. What? You don't want to talk to him? You don't? I'm not talking to him. I'm going to talk to you. What do you? Go ahead, Mr.
Your Honor, I cannot explain my client's back for appearance here today. I did call the number we had on file, but it was for someone else who told me they were not Mr. Jamie Bailey. So I'll be asking for an adjournment at this time to allow me time to get in contact with my client.
Bench warrant will issue. Bond 10,000. Cash surety.
And Your Honor, just for the record, it looks like this person previously failed to appear in September. And then they got arraigned by the magistrate on December 22nd and got a PR. So I'm going to request.
Well, we'll do the 10,000.
Yeah.
And I dare Odie to do it again. All right. That warrant with this warrant will issue immediately.
Understood, Your Honor.
Court calls the case People versus McKell. Is it Urquiza?
I believe it is Urquiza, Your Honor.
And then on behalf of people.
Assistant Public Defender Davia Leba on behalf of Mr. Urquiza. And Your Honor, Mr. Urquiza would like to waive his preliminary examination, and if you'd like.
Your name, sir?
Miguel Urquiza. And Your Honor would like to address bond as well.
Of course you would. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yeah.
You understand you will not have that hearing, you'll proceed to circuit court for further resolution.
Can you give me a second? Yes. Oh.
Oh. How many more of those?
I think it's a good decision, but it has to be. Yes.
Yes, understand.
All right. You understand you will not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, and we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for January 13, 2026, 1:30 before Judge Conkey. As to bond.
And with regard to bond, I think the past couple weeks in jail have taught Mr. Urquiza a very significant lesson, both about the seriousness of this case and about the importance of following this court's orders regarding bond. He is 20 years old. He is a college student, University of Michigan. He has a supportive family. I believe both his parents are present in the courtroom today. He's told me he is actually doing very well in school. It's a 3.5 GPA, and he's currently scheduled to go back to school on the 7th. He's also told me that he was accepted recently to him.
Why did he lie to me when he came before me?
Mr. Urquiza, would you perhaps like to address the court on that?
Like regarding to the Adderall?
Yeah.
Well, yeah, I did. Well, a family member did take it, and I made a careless decision of taking it. I knew it was going to bring me consequence. I didn't think about the consequences before doing it, and which now, I know.
Once you got caught, so I guess what I don't get is once you got caught, why'd you lie to me? I mean, I look stupid, but I'm really not.
No, I'm not trying to say that, Judge, but after just.
Okay, why'd you lie? Oh, that's a hard question.
Just say you took it. You were scared. Just say that.
The reason why I lied was I was scared. I just didn't know, the consequences I'll be following it.
Really?
And that was.
So how'd that work out?
It didn't work out really good.
It really didn't.
My fault. So, but after spending, almost 2 weeks, in jail, I learned that freedom is like a privilege that many others take for granted. And, after learning that and if given, a chance, I won't take that for granted.
You came up here, it's really funny, because you came up here really smug and everything, just doing what you're doing. And I asked you a simple question. You just lied to me, tried to smile at me like whatever it was. And you didn't seem to get it. I don't play that.
I understand.
No, I don't know if you do. Lucinda?
Your Honor, at this point, I would object. I think maybe a release to inpatient might be appropriate at some point, based on the mistest, the THC, the Adderall, and then he was intoxicated as a part of the underlying charges. So I think there are some issues that need to be figured out before he was just released back in the community.
Your Honor, I have no objection to him being released basically on home confinement with an instruction to immediately get a substance use assessment. But as of now, I don't think there's any reason to believe that he's in need of inpatient treatment.
Okay, let's look at this. How am I gonna keep him away from the drugs?
Your Honor, I think the past 2 weeks have taught him that he cannot even think about touching substances. I think that's very clear to him now.
So he should have learned a number of lessons. Don't touch that. Don't lie to me.
I think this is probably the biggest learning experience of Mr. Aki's life, Your Honor.
Really?
Would you agree with that,
That's a
Mr.
lot of
Akiza?
money to pay
Yes.
for the U of M. This becomes your biggest learning. Where are you from?
I'm from Chicago, Judge.
Oh, he's trying to roll some Chicago stuff on me. That didn't work, did it?
I'm sorry?
That didn't work, what you were trying to do. Why didn't you just come in and tell the truth?
Well, I was scared. Well, I've never been in this type of situation before in my life. You know, I've never been in trouble. I've never been in the state. You know,
Why didn't you just tell me the truth? Did you think lying was gonna get you anywhere?
No.
I mean, that's the other part. Did you think it was really gonna get you anywhere?
no.
Why did I have all these missed tests? Because that's the other thing.
Your Honor,
Remember this one, that's like positive THC.
Right. I'm sorry. I meant to phrase it differently. You don't have a medical marijuana card.
I don't. But after my release, I don't know why I showed up positive and negative. It was,
You don't know why?
no, I didn't, you know, after my release from, you know, Washtenaw, I didn't take any edibles or I didn't consume any THC. I obviously knew and learned not to.
So how did it get into your system? You're an amoeba. It just absorbed into your system? Why do I get the feeling you're not telling me the truth?
Your Honor, Mr. Akiza has indicated to me the whole, pretty much since this violation of THC came to light, that he does not believe he's used THC since.
So this THC, how did it get into his system?
That I don't know, Your Honor, but
Really? You don't know? You weren't there with him?
I was not, Your Honor.
Okay, so he knows.
I believe.
I don't know. No, you know what, young man, here's what we're gonna do. And I hate holding everybody up, particularly the jail. They've been great today getting these people out. I've got some others that are in custody that have to come out. I'm gonna send you back. I'm gonna do you the favor of recalling your case at some point when you have a chance to speak with your attorney and decide you're gonna tell me the truth. I'm not stupid. Don't say anything because otherwise my decision is gonna be you're gonna sit. Take it back. Clerk does call the case of the people versus SAR.
Yes, Your Honor, ready.
People.
Morning, Honor. Tyler Velo, P number 75702 on behalf of Pendasar, who is walking up to the podium and will be standing to my right momentarily. And Ms. Sar, when you get to the microphone, can you state your name for the record?
Yes, Pendasar.
Yes, today is the date and time, Your Honor, for a probable cause conference. My office reached out to the prosecutor as late as yesterday regarding discovery, and they didn't have it, but this morning they did, and they told me that they sent it to me, so to my office. So we have that now, but we are asking for a short adjournment here so that we can review that discovery and decide on the preliminary examination.
Cause conference, January 15th, 2026, 9 a.m.
Thank you, Your Honor. Have a great day.
bond will continue. You need to fill out a green sheet, counsel.
Thank you, Your Honor.
All right. Thank you. Court does call the case People versus Emily Bates.
Water Assistant Prosecuting Attorney for the People.
Brian Bowling on behalf of the state. We should be on Zoom, hopefully.
Hello, Your Honor. Happy New Year. Happy holidays.
And to you, Miss Bates. Thank you.
Thank you.
Judge, at this time, I believe the people are going to move to dismiss this matter.
That is correct, Your Honor. Defense has provided me with various documents verifying treatment that Ms. Bates is doing here. But she is well engaged in mental health treatment where she's currently living. And so in the interest of justice, the people will be submitting a motion to not be brought. And with the hope that she continues to do that.
Any objection?
No objection, Judge.
Ms. Bates, this case is dismissed.
Thank you, Your Honor. It was a pleasure to meet your company. I wish you the best of luck in the new year. Thank you. God bless.
I was actually going to say that you were, every time you appeared, you were always very pleasant and very nice. And I appreciate that. It doesn't go unnoticed.
Likewise, Your Honor. Thank you so much.
All right. You take care of yourself.
It was nice to meet you as well.
Have a good New Year.
Thanks, Judge. Thanks, Mr.
Thank you.
Court calls the case People versus Jade Wimberly.
Assistant Prosecutor, on behalf of the people. Brian Bowling on behalf of Ms. Wimberly, who's approaching. State your name for the record. Your Honor, we're asking for an adjournment to attempt to get some video from the officers related to this incident. So I just asked for an adjournment.
Okay. Do the people have it or what?
I just got an email from the OIC. It was a body cam case from 2018, I believe. So unfortunately, they did not retain that body cam.
Okay. Well, I guess based on that, Judge, we would ask that this matter be set for a preliminary examination.
All right. Discovery would be complete, and would the people have their witnesses available the 13th?
Yes, sir.
Preliminary examination in this matter, January 13th, 2026, 9 a.m. before a 15th District Court judge.
Address bond.
Right.
Judge, Ms. Wimberly being held on a $10,000 bond. She does also have a bond out of the 14A2 District Court, which is a $1,000 10% bond, which she indicates to me that if this court were to grant her a personal bond, she would be able to post that bond. There's nothing else holding her in custody to my knowledge. As the people indicated, this is an older case. It involves an allegation of abuse with her young son, who is now significantly older.
Why didn't she show up?
In the most recent hearing in December, Your Honor, she was at a facility called Stonecrest in the city of Detroit. My office was working with Ms. Wimberly's sister, as well as that facility, to try to get documentation for the court, but we weren't able to do that. I believe if she's able to get out, she can present that to the court when she returns.
How long was she in that?
I was in there from January, the second last week of January, all the way to February, past February 14th.
That was the first one back in January, Judge. And then recently, when were you there in December, early December?
December.
Yeah.
I wasn't there in
The
December.
Stonecrest was in
But
January.
I
I'm
guess
sorry.
what I'm saying is,
That's my
we
understanding.
didn't hear from her. She didn't appear before me in January of 2025.
Yes, and that was due to the Stonecrest issue. I had some
Okay.
misunderstanding with respect to
After
December.
that, we don't hear from her until December, and there's nothing. And then the question becomes, how'd you come into custody?
My mother called the police. I didn't even know I had a warrant.
She was arrested on the matter pending at the 14A2 District Court with that bond that I addressed earlier.
Got it. Well, I'm gonna leave it in place at this time. I'm gonna deny the request for bond reduction.
Thanks, Judge. Thank you.
Court does call the case of the people versus Bridget Beck.
Ashley Feltus for the people.
Stephanie Cannon on behalf of Ms. Beck, who should be appearing by Zoom.
Bridget Beck. What? I don't.
She's not your second screen, but I'll.
I mean, I see your name. Oh, okay.
Ms. Beck,
Ms. Beck, you need to mute yourself.
you need to unmute.
Oh, can you hear me now?
Now we can hear you. State your name.
Bridget Beck.
Your Honor, I do have a green sheet for Ms. Beck. Your Honor, this case is kind of old, but I don't
Kinda
have,
old.
yeah, I don't have any discovery yet. I'm not sure whose case is, sorry.
It's old.
So I'm just adjourning it so we can get the discovery.
Adjourn it February 5th. 2026, 9 a.m. bond continue. Thank you.
Thank you, Your Honor.
Court calls case people versus Carla Bordine.
Ashley Feltus for the people.
Here for Carlos.
Bordine.
Yeah, Your Honor, apologies. I think earlier the court adjourned her hearing to February 5th, I understand, to so that it's held with co-defendants.
Through all of the discovery. Is she here?
She did leave. I think she understood that the case had been addressed and that it was adjourned until February 5th.
Her co-defendant was called Mr. Killawald's
Yes.
client. She may have misunderstood.
Yes, yeah, that's apologies. I didn't.
But
correct
she
that.
was here
She was here. She was present.
and we adjourned that to February 5th.
Yes, wrong.
Probable cause conference will be adjourned February 5th, 2026, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Case people versus David Brown.
Prosecuting attorney.
Assistant Public Defender Chelsea Regil with on behalf of David Brown, who approaches. Come on up, Mr. Brown. State your name.
David. Brown. What are we doing?
I'm asking to adjourn. I didn't have an opportunity to speak with Mr. Brown before court today, so I'd like to go over discovery with him.
January 29, 2026, 9 a.m. bond continue.
Thank you, Your Honor.
Court calls the case of the people versus Nathan Burgess.
Another order, assistant prosecutor.
This is the one. Who's on this? Let's go.
Your Honor, Stephanie Cannon on behalf of my client standing in for Mr. Vivo. Could you please state your name for the record?
Nathan Burgess.
I have before me a plea form. Is that what we're doing?
Yes, Your Honor, we're doing a plea in this matter.
The plea form indicates that the defendant will be pleading no contest to 3 misdemeanor charges. Count 5 of larceny, 200 to 1,000. Count 6 of false pretenses, 200 to 1,000, and count 7 false pretenses, 200 to 1,000. Upon his successful those are all 1-year offenses. On his successful no contest plea, counts 1 through 4 would be dismissed. That's the court's full understanding of the agreement.
That is my understanding, well.
Your Honor, that is our complete and full understanding of the agreement.
May I have him sworn?
Raise your right hand. Do you solemnly swear the public testimony you're about to give, whole truth and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Nathan Burgess.
Sir, it is this court's understanding that you're gonna plead no contest to 3 misdemeanor charges. Is that your understanding?
Yes, sir.
Says, first of all, to count 5, larceny 200 to 1,000, that's a misdemeanor punishable by up to 1 year, $2,000 fine plus court costs. You understand that?
Yes, sir.
And also 2 counts of false pretenses, 200 to 1,000, constituting counts 6 and 7. All of these offenses are 1 year misdemeanors, are punishable by up to 1 year, $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property, which is either the subject matter of the false pretenses or the larceny. If that's greater than $2,000, that would become your maximum fine. How you do?
Understood.
Understand that? All right. You understand what a no contest plea is?
I do, yes.
All right, 2 things about it. I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these. You need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty.
Understood.
You understand that? Basis for the no contest plea?
Potential civil liability, Your Honor.
All right. Sir, I also have to advise you that while I'm taking these, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
I do, yes.
All right. Still wish to plead no contest?
Yes, sir.
To the charge of larceny 200 to 1,000, how do you plead?
Guilty.
No contest.
No contest.
To the charge of false pretenses as contained in count 6, how do you plead?
No contest.
To that same charge as contained in count 7, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Understood.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
Yes, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
I do, yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, they haven't.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
I am.
and of your own free will.
Yes, sir.
All right. Course has been provided and had reviewed Michigan Department or Eastern Michigan University report for their case number 255779. Any objection to the court having reviewed that report?
No, Your Honor.
No objection, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could have determined a defendant's guilt to these charges of counts 5, 6, and 7. Sir, I do have to advise you that if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
I do, yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
People are not.
I'm not aware of any, Your Honor.
And have I complied with the court?
People are satisfied, Your Honor.
The court has, Your Honor.
Court will accept the defendant's plea of no contest. 2 counts 5, 6, and 7. Counts 1 through 4 are dismissed. A pre-sentence investigation and report is ordered at 1482 probation. Sentencing will be
January 21st, 10 a.m. before Judge Barr.
January 21st, 2026, 10 a.m. before Judge Barr. Bond will continue.
Thank you.
Thank you. Court calls the case, People versus Jason Campbell.
The water assistant prosecutor.
Assistant Public Defender Don, if you leave with Mr. Campbell, and I do have a green sheet. Your Honor, Mr. Campbell, to my understanding, was released to treatment from the jail, and I've not been able to reach him. I believe he was released to treatment within the past couple days.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls the case of the People versus LaShawn Charles.
And the water assistant prosecuting attorney for the people.
Stephanie Cannon on behalf of Ms. Charles, who should be appearing by Zoom, Your Honor.
Yes, I just need her to state her name.
LaShawn Charles.
Thank you. You're asking for an adjournment.
Yes, Your Honor. Yes, I do believe we have probably come to a resolution on this matter. Some of the facts have to be nailed down, but I do believe
January
that the next.
29, 2026, 9 a.m. bond.
Okay. Thank you, Your Honor. I'm sorry. It includes needing to get $1,000 into the court. I do believe
Can't do it that way.
Okay, thank you,
You
Your
guys
Honor.
have to figure that out. Give it time to figure it out. Court calls
Thank you,
case
Your
People
Honor. Happy
versus-
holidays.
And to you. Court calls case People versus Deborah Collette.
Assistant Public Defender Jay Butler on behalf of Ms. Collette, who should be appearing via Zoom, Your Honor.
You got her. Oh, there she is. Ma'am, you need to unmute.
Looks like she's still muted.
Still muted.
Me?
There you go.
No, that's
Did he
not her.
come in?
Damn it.
Miss Collette, can you unmute? She's trying.
Who you call?
Miss Collette, do me a favor, wave your hand if you can hear me. Okay, you're just asking for an adjournment.
I am, Your Honor.
All right. Go ahead.
I am asking for 3 to 4 weeks. She is recovering right now, and she still has to provide me some information for purposes of mitigation.
January 29, 2026, 9 a.m. Did you hear that date, ma'am? If you heard the date of January 29, 2026, wave your hand and let me know. All right, very good. Okay, your bond will continue. Thank you, ma'am.
Thank you, Your Honor.
All right. Court calls case of the People versus Corey Copeland Nash.
Can I get off here?
Thank you, Your Honor. Alex Warren Green on behalf of Ms. Copeland Nash.
I have a plea form. Is that what we're doing?
Yes, Your Honor.
That's correct, Your Honor. Ms. Copeland Nash, can you state your name?
Corey Copeland Nash.
All right. Plea form indicates she's going to plead guilty to the charge of attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. Upon her successful plea to that charge count, that being count 2, count 1 would be dismissed. And that's the court's full understanding of the agreement.
That's our understanding, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear to put on testimony about to be the truth, the whole truth, and nothing but the truth, so help you God? State your name, please.
Corey Copeland Nash.
All right, ma'am, it is this court's understanding you're going to plead guilty to the charge of attempted possession of a loaded firearm in or upon a motor vehicle. That is a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon or device. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Right.
You signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Okay, of your own free will.
Yes.
All right, because you believe that you're guilty of this offense, ma'am?
Yes.
On the date of September 27th, 2025, at the location of Lake Point Lane near Briar Parkway in Pittsfield Township, Washtenaw County, State of Michigan, were you in a motor vehicle?
Yes.
All right. Did you have a pistol in that motor vehicle?
Yes.
Where was it located?
My purse.
In your purse? Okay. Ma'am, did you have authority to carry that weapon in that fashion?
Not at that time.
Not at that time. All right. Was it loaded?
The clip was in the purse as well, but it wasn't in the gun.
It wasn't in the gun. You don't know whether or not there was one in the chamber.
No, I know it wasn't.
There was not one.
There was not.
Okay, gotcha. All right. Ma'am, I do have to advise you, if I accept your plea and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, commit misconduct as defined by the Michigan court rules, that the court would no longer be bound by any sentence evaluation or recommendation. And you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, you're aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None from the defense,
And have I complied with the court?
You are satisfied.
and the defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be February 11th. Really? 2026, 9 a.m. That's before me. Bond continues. Oh, wait.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Vasquez Davis.
Assistant Prosecuting Attorney for the people.
Assistant Public Defender Ben Dunaway on behalf of Mr. Davis, approaching the podium now. Your Honor, we just received an offer in this matter today. Mr. Davis, come on up and would you state your name for the record, please?
My name is Vasquez Faison Davis.
Okay, so we just received an offer today from the people. I'd like to put that on the record and adjourn a couple of weeks for Mr. Davis to think about that.
Go ahead, put it on.
Your Honor, the offer for me to plead guilty to 4 no contest to 1 count of malicious destruction of property, 200 to 1,000. And the restitution, we believe, is in the amount of $500.
Is that payable at plea or sentencing?
After sentencing.
After, okay.
I'll adjourn this matter out January 22nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Thank you. Keep your phone away till you get out of my courtroom. You know, yeah, that's funny. I'm serious.
Is that the 29th, Your Honor?
22nd.
22nd, thank
What was that about, man? Was that a friend of yours? What? Huh? Was he laughing at you? Why don't you take the phone? Huh? I just have to tell you everything. No, I'm done. Done. Court calls the case. People versus Eric L.C. Williams.
Assistant Public Defender Chelsea Vergil, on behalf of Eric L.Z. Williams.
Your name?
Eric L.Z. Williams.
All right, what are we doing?
Your Honor, I'm asking for a very brief adjournment. I apologize. I did not realize Mr. L.Z. Williams was here today. There has been an offer, and I'd like time to discuss that with him.
Cause conference. January 29th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir. Court calls case of the people versus Ayana Fan.
And the water assistant prosecuting attorney for the people.
This is the other Fan.
Hi, I'm on Zoom.
Yes, you are.
Silly. Let's pick up a letter and then let's find out where it goes. What letter is this?
Sir Danaway, you need to turn off your background noise, man. Ma'am.
Assistant Public Defender Ben Dunaway on behalf of Ms. Ben.
Ms. Ben, state your name, please.
Ayana Fan.
All right.
Okay, so we have a resolution in this matter, Your Honor. May I provide the plea form and the advice of rights to the deputy?
All right, the Form indicates she's gonna be pleading guilty to charge of retail fraud, second degree. The 1 year offense. Upon her successful plea to that charge, count 1 would be dismissed. There is also a sentence agreement of probation under HYTA. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Yes.
That's court's full understanding.
Yes, Your Honor.
Ma'am, please raise your right hand.
Oop, hold on, wrong hand.
Yeah, your other right hand. There you go.
What? I don't know.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again, please.
Ayana Pham.
Ma'am, it is this court's understanding that you're gonna be pleading guilty to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Can I be sentenced before you?
Counsel first, please.
Go eat your food.
Ma'am, at this time, what I'm gonna do is I'm gonna stop the plea. I'm not gonna take your plea at this point in time. And I'm going to adjourn the probable cause conference out to January 22nd, 2026 at 9 a.m. I was gonna go ahead with your plea despite the fact that you weren't supposed to be appearing via Zoom, but now you have a question regarding the sentencing judge, and I'll let you talk that over with your attorney. But we'll obtain all the paperwork, but I'll put it on the 22nd. Thank you.
Email or call us, Ms. Fenn. Thank you.
Okay, thank you.
Court calls the case, People versus Robin Finney.
Assistant Prosecuting Attorney.
Assistant Public Defender Jay Bellinger on behalf of Ms. Finney, who should be on Zoom, Your Honor.
Yes, Your Honor.
Oh, there you are. Okay, state your name, please.
Yes, Your Honor. Robin Finney.
Why you got that Spartan on your shirt?
My girlfriend gave it to me, Your Honor. So I have to wear it.
You should ask for better gifts, like a turtle.
Yes, Your Honor.
Just saying. I don't know what that Spartan is. It made me feel uneasy.
Can I get a second?
What are we doing? What are we doing?
Mr. Childers now the process case, so the order.
What?
I wasn't there, but it was extraordinary advocacy, I'm told.
And I would have to give some credit to Ms. Plumai as a result of that as well.
She wore him down?
She did. She did.
Wow. She's
I
dangerous.
just had the assist, Your Honor.
All right. So if they're in Spartan stuff, do I dismiss it? No? All right.
Your Honor, if you give me.
What I will do. What'd you say?
I can change my shirt, Your Honor.
No, you're good. Don't worry about it. We're good. Case is dismissed. Now they
Yes,
press.
thank you, Your Honor.
Thank you.
Thank you.
Have a good new year.
Thank you, Ms.
Happy
Penny.
holiday.
Good luck.
Thank you.
Court calls the case, People versus Matthew Fitzgerald.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Fitzgerald, who should be appearing via Zoom.
Yep.
Okay, there you are. State your name, sir.
Matthew Fitzgerald.
Okay, what are we doing?
At this time, Your Honor, I'll be asking for an adjournment to complete some plea negotiations. I do have a green sheet.
Probable cause conference, all January 22nd, 2026, 9 a.m. bond continue.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Have a good one.
You do the same. Court calls the case of the people versus Brandy Graham.
Allison, on behalf of the people.
Asli Bashir on behalf of Brandy Graham, who I believe she
She is
may.
on Zoom.
On Zoom, yes.
Ma'am, unmute, state your name, please.
Brandy Graham.
All right, what are we doing?
Thank you. We're requesting an adjournment. I did speak with Assistant Prosecuting Attorney Zenda, and I understand that the discovery is being sent over. It may have been sent over today.
January 15, 2026, 9 a.m. bond continue.
Thank you.
Thank you.
15. Court calls case of the people versus Joseph Hafner Cantor.
Alex Warren, Green on Hafner Cantor. Here, Your Honor. Can you state your name?
Joseph Hafner Cantor. All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond
continued. Thank you.
I think the last time we were here was December the 4th.
Pardon?
Last time we were here was December the 4th. I have a violation dated December the 9th. Bond violation. of course.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation? I do. Behind that, I need these in the front.
So Your Honor, it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th. And I've got,
So it does appear that these tests were in the interim period between the last time we were here and this.
Mr. Allen.
With positive alcohol blows on the silver link.
We've got a positive on December 8th. And then missed tests really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him. And he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that now.
Really?
He did appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be arraigned on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Frushauer, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond
on this case,
he was taken into custody at the time of his arraignment.
you're saying two different things to me. Her taking him into custody at the time of the arraignment is one thing. If she's taking him into custody on this case, that's a different thing and not something that I see in this file.
And you're correct. What happened was after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a scram tether before that bond shifts to a personal bond. So he was fitted with a scram tether. He remains on that scram tether since December 9th, and I don't believe he's had any violations. Mr. Hafner-Cantor is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond because I think him being on a scram tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI and he admits he has a drinking problem.
Yeah, but this response from the people.
The people are glad that he has now a scram order on the OWI case that's pending before Judge Freshour. However, it's still a violation in this case to have been drinking. I'm not sure. I know the court generally will issue warrants pretty quickly when these things sort of come through. I'm not quite sure what happened here, but no matter what, it does.
Was there a warrant issued on this one?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that SoberLink is not working. So I would ask that the court at the minimum order the scram in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
He did not give me one.
So there was a warrant issued on this one, okay.
Okay.
Is it still out?
For Mr. Hafner?
Yeah.
Okay.
No, I do not see that warrant.
Oh, you do not see that one.
No. So he was, the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation would be sent and I was affording him the opportunity to take ETG test to provide results with my report if in fact he was not drinking. And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of timeframe.
So when did he appear before Judge Freshour?
It looks like December the 9th.
That's correct.
What time?
9-ish in the morning.
So she may or may not have been aware then.
She was aware, she remanded him and.
But was she aware that he was intoxicated?
Mr. Cook's note indicates and his communication to me indicates that he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court. And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drink coming into court, you drink in violation of my bond. I saw you 4 days beforehand. And no, we don't do that. Say whatever you want.
Your Honor, I think what Mr. Hafner kind of wants the court to consider is that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying his problem.
Right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner-Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the scram tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually touched at the court, but because he had the 0.04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make
So he wasn't breathalyzed at court.
now that Mr. Cook's aware.
Where
But
it's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair, yeah.
Anything else?
Your Honor, I know Mr. Hafner-Cantor's been in constant contact with his community corrections agent. And I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter. And
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment. Anything else?
Nothing from the view.
nothing further, Your Honor.
Bond revoked, defendant's remanded.
Your Honor,
Yeah.
and
The 13th is.
And with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
District court where?
for the OWI case.
Well, he wouldn't examine until much later.
Which judge is the exam?
Me.
Thank you.
Thank you, Your Honor.
Court calls case People versus Nicholas Harding.
Assistant prosecutor, defendant of the people.
Assistant Public Defender Dobby Lebo on behalf of Mr. Harding. Mr. Harding, could you please tell the court your name, sir?
Nicholas Harding.
Alexander, on behalf.
Where's the wrong name?
And Your Honor, we are requesting adjournment of this matter. We have received an offer that Mr. Harding is considering. I'd just like to have him to have some time to reflect.
January 15, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case of the People versus Daniel Hardy.
And the water assistant prosecutor, defendant of the people.
You got too many people. So that's
Assistant Public Defender Ben Dunaway on behalf of Mr. Daniel Hardy, who should be on Zoom.
I am here.
Okay, Your Honor, we are prepared to waive exam today. We do have an offer. We'll be taking advantage of it, circuit court. If we could ask the prosecutor to place that on the record.
The offer is that Mr. Hardy pays half the restitution, which is approximately $1,000 prior to the plea. Then he can enter a plea under 771(1) deferred. That is contingent on him paying the remaining amount of restitution to take advantage of that.
And Mr. Hardy, do you understand that? And do you wish to waive your exam to go to circuit court to take advantage of that offer?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand that you will not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We will stand mute. We have the formal reading.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
February 25th at 1:30 before Judge Conlon.
February 25th, 2026, 1:30 before Judge Conlon. Bond will continue.
Thank you, Judge.
Thank you. Court calls the
Thank you.
case of the people versus Robert Harris.
Assistant Prosecuting Attorney for the People.
Asli Bashir on behalf of Robert Harris. Mr. Harris,
You're requesting an adjournment
yes, for further negotiations, Your Honor.
Your Honor, we briefly approached.
very briefly. I will adjourn this matter, probable cause conference to January 29th, 2026, 9 a.m. His bond will continue. He paid money to 50. District Court would say accepted apparently. So I don't know what the deal is, but we need an order.
Okay. Thank you, Your Honor.
Court does call the case of the people versus Ardashir Hassani.
And the other Prosecuting Attorney for the People.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Hassani, who is standing to my side. Can you please state your name for the record, sir?
Yes, Ardashir Hassani.
All right.
At this time, Your Honor, I'll be asking for a brief adjournment to finalize some plea negotiations.
Probable cause conference, January 15th, 2026, 9 a.m. I'll need a green sheet.
Your Honor, we'll be sending over a stipulation to travel where my client will be traveling from January 5th to January 20th. So would it be possible to get the 22nd date?
Where is he going?
You're going to Canada, correct?
Yes.
Going where?
Canada.
Canada?
Our fellow finished
The whole place? Where in Canada?
Toronto.
Toronto?
Yes.
Oh, no. Things happen in Toronto. Beautiful city. Love the place.
Yes.
For that long?
For 2 weeks. Yes.
Not right about this. I'm not sure. January 29th,
Thank you, Your Honor.
and I'll wait to get the,
That should be being sent over shortly.
pardon?
The order should be being sent over shortly.
All right, very good.
Thank you. Happy New Year.
And to you. Court calls the case, people versus Daniel Elan.
Ashley Feltus for the People.
Is that Mr. Hammond, Your Honor?
Elan?
Yes.
Search, unmute, state your name.
Daniel Heelan, Your Honor.
And Assistant Public Defendant
Need
Nicholas
his name
Bukovich
changed.
on behalf of Mr. Heelan.
What are we doing?
At this time, Your Honor, we're requesting a adjournment for purposes of pre-negotiations. Mr. Heelan just got into treatment, so.
January 29th, 2026, 9 a.m. bond continue. Thank you, sir.
And Your Honor, I'm also handing you the green sheet for Mr. Hassani's file as well.
That's right.
Can I say
At the
something?
time that the case is called.
Yeah, I'm actually in treatment right now.
What?
I'm in intake. I'm in treatment right now, Your Honor.
That's what I said, Mr.
We already got that.
Oh, okay.
We'll see you on the 29th. Thank you.
Thank you, Your Honor.
Court calls case people versus Robert Jameson II.
Ashley Feltus for the People.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Jameson, but not with.
Not with.
Not with.
Bench warrant will issue bond 10,000, cash surety. The warrant will issue immediately. Court calls case of the people versus Cyrano Johnson.
Assistant Prosecuting Attorney for the people.
Stephanie Cannon on behalf of Mr. Johnson. Mr. Johnson, when you're at the lectern, please state your name for the record.
Cyrano Johnson. How are you?
Thank you, sir.
And Your Honor, I do believe we're close to a resolution on this matter. However, I would just ask for a brief adjournment, hopefully for a plea.
I'll do it this way, January 29th, 2026. 9 a.m. bond continue.
You say January 26th, Your Honor?
29.
29th, I was so close.
I'm glad you were listening. All right,
Oh.
we'll do it then. Thank you.
I'm 60.
Thank you, sir. Better leave Mr. Johnson alone. Court calls the case, people versus Jalen Johnson.
Assistant Prosecuting Attorney for the people.
Brian Bowling on behalf of Mr. Johnson. Your Honor. Your name for the record.
Jalen Johnson.
Judge, I'm asking for an adjournment to try to obtain body cam footage from the police that I know Mr. Overwater is working on, as well as I'd like to do some investigation work within my office.
January 29th, 2026, 9 a.m. bond continue.
Please not get notice yesterday, so.
Court calls case, people versus Gregory Jones.
Patrick, on behalf of Jones. Your Honor, we are requesting an adjournment for further negotiations in this matter.
Probable cause conference, January 15th. 2026, 9 a.m. bond continue. Court calls the case of the people versus Jimmy Lips.
Water Assistant Prosecuting Attorney.
Brian Bowling on behalf of Mr. Lips, who's approaching.
Your name, sir?
Jimmy Lips. Your Honor, I'm asking for an adjournment in this matter as well, looking to get surveillance footage from the store. I know Mr. Overwater is working on it.
Probable cause conference, January 29th, 2026, 9 a.m. bond continue.
Thank you, Judge. Yeah, give me a minute. I'll give you a notice for that.
Court calls case of the people versus Austin Lobestall.
Water Assistant Prosecuting Attorney for the people.
Brian Bowling on behalf of Mr. Lobestall. You should be present on Zoom.
Lobestall, can you state your name, please, sir?
Austin Lobestall.
All right. Since court's understanding, I have a plea form in front of me that indicates he'll be pleading guilty to an added count 2 of larceny by conversion 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is agreeing to pay $5,000 in restitution. There's a sentence agreement of deferred sentence under 771.1 under the condition that restitution is paid in full. That's the court's full understanding.
That is correct, Your Honor.
That's my understanding as well, Judge.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes.
State your name for the record.
Austin Lobestall.
All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of larceny by conversion 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased 3 times the value of the property taken. If that's greater than 2,000, that would be your maximum fine. You understand that, sir?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
They signed it on my
You had your
behalf.
attorney sign one on your behalf?
Yes.
after going through it, do you have any question regarding any of those rights?
Nope.
Looking at paragraph 5, you understand also that you're waiving all of those rights on that form, including your rights that are your trial rights, which are contained under paragraph 5. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes,
Are you on probation or parole?
I am, but I was not while this, when this
What, you
incident
weren't at
occurred.
the time that this happened, is that correct?
Yes, that is correct.
I can do it.
Has any-
We're in the diaper team.
Really? Got it. Has anybody promised you anything other than what's been stated here today to get you to plead?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily and of your own free will?
yes,
And also because you believe that you are indeed guilty of this offense?
yes,
July 1st, 2024, at the location of 14655 Hines or Hinsey in Manchester Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I took a deposit on a job and I did not complete the job and did not return the money.
And it was a contracting type of work?
Yes,
All right. And the funds that you took, you converted those funds to your own use?
yes,
And the amount was in excess of $200 that you took?
yes,
Okay, sir, if I accept your plea, I need you to understand if you commit misconduct between the time I accept your plea and the time of sentencing, that's misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
yes.
Counsel, you aware of any other promises, threats, or other inducements which have led to this plea?
I am not.
And have I complied with the court rule?
People are satisfied.
I agree, you have.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. The pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be February 3rd, 2026, 9 a.m. before Judge Freshour.
May I address one issue regarding bond, Judge?
Yes, please.
Mr. Lobestall would like to go to Ohio with family.
For
They,
what reason?
they own a cottage down there that they need to do some.
In Ohio?
Yeah,
They have those?
they do,
Okay, go ahead.
apparently. From January 3rd, returning on January 7th. So we'd ask for your permission to allow him to
To
do,
go to Ohio
to go to Ohio. Mhm.
on purpose.
Apparently.
What part of Ohio?
Near Athens.
Oh,
The people do not object if Mr. Lobsdale wants to punish himself prior to sentencing.
well, if there's no objection, I guess I'll let him go.
Awesome, thanks.
Thank you, Your
Bond
Honor.
will continue. What are the dates you're going?
January 3rd through January 7th.
3rd through the 7th?
Correct.
You'll take care of that. All right. Thank you.
Thanks.
Thank you.
Travel safely.
Thank you.
They don't even have roads. That's what I hear. Do they? They do? You know, oh, you're from Ohio. You are, aren't you? I mean, the other side kind of, because you're from like Cleveland area, which nobody claims. Yeah, but do we really listen to that? No. Okay, good. Nice chat. Court calls the case, people versus Quadir Man.
I said on behalf of the people, Your Honor.
Assistant Public Defender Ben Benowitz on behalf of Mr. Mann, who is standing to my right. Sir, would you say your name for the record, please?
Quadir Man.
Thank you.
Your Honor, we would like to set this matter for exam.
All right. Discovery is complete.
Discovery is complete.
People had their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before 15th District Court Judge. Yes.
Your Honor, it came to my attention in looking at the defendant's jail calls before he was released and after he was arraigned. He made 50 calls to the victim from his PIN to her listed number after being arraigned. And that doesn't count the day that he was arraigned after he was arraigned. That only encompasses days exclusively after he was arraigned. He calls her 50 times. So I have concerns, given that also at arraignment, the magistrate indicated his concerns that he will not follow court orders and that he would go back to contacting the victim as soon as he was released. And it seems that he didn't even do that prior to being released. He did it while he was still in custody. So I have concerns, given now that he is out, for safety. I also have concerns given the facts of this case in which his grandmother is the person who reported the crime after she awoke to blood-curdling screams from the victim and felt she had to call 911 after hearing the victim being slapped. So I have concerns for safety given that he was contacting her excessively from jail.
When was he released?
I'm sorry, could you?
When was he released from jail?
I believe it was the 26th and he was arraigned on the 24th after being arrested on the 23rd. Could I attempt to respond, Your Honor?
Go ahead.
My response is primarily based on the facts of the case. This complaining witness stated she was not assaulted. The grandma did not witness any sort of assault. As the prosecutor told you, she said she heard something. So there's no witness that actually witnessed an assault. So then, Your Honor, the police say he's laying on a mattress with a blanket on him, which we would commonly call sleeping. The complaining witness tells the police he has a head injury from falling down, okay? So he's sleeping and has a head injury. The facts of the felony charge in Washtenaw County in 2025 is that he had to be told 3 times to turn around and 4 times to back up. And that's a felony. And now we want to revoke his bond, which is basically a due process violation because you take away his trial right. His trial will be in about 8 months.
Why am I taking away his trial right?
Because if he's incarcerated, then it's make a get out of jail plea. I mean, he's talked to
It's not counsel. And quite frankly, this court resents that you even make that argument that this court would be involved in violation of anybody's due process rights. He's given conditions. If he does not follow those conditions, he pays the consequence.
I agree. I just indicate to the court, I don't think the person that the condition is regarding wants that condition. She didn't want any of this. And then
there's a way in which that's taken care of, not by him continuously calling. He knows he's not supposed to be
I mean, Your Honor, he's 19 and it's Christmas. I just asked the court to give him a chance until we have a date on the 13th. I mean, if this witness says he's contacting her currently, you know, she comes to court on the 13th and tells the court there's a bond violation. I clearly don't have an argument to that, but if the court would let him stay out to the 13th and he's not going to contact.
I don't know what he's doing now. I mean, that's what part of the problem is. Part of the problem is that, and by the way, not only is your client entitled to due process, but the people are entitled to due process. Everyone is entitled to due process, and it is my job to make sure that it happens. If I believe for whatever reason that he may be interfering with the people's due process rights to fairly present their witnesses and have their witnesses present, then I'll take action, which I'm about to do now. Right now, his bond is revoked. Defendant is remanded. Thank you. Yes, and his phone privileges while in jail are revoked. Put that, can you?
Would the court only revoke as to the 2 persons with no contact orders?
I'm revoking his phone privileges.
Okay, thank you.
Court does call the case, People versus Kelton Martin.
That was an unhappy people, Your Honor.
Stephanie Cantor on behalf of Mr. Martin, Your Honor, who is present. Mr. Martin,
Hands out of your pocket.
Well, I apologize.
could you please state your name for the record, Mr. Martin?
Mr. Martin.
What are you doing?
Your Honor, I'm asking for an adjournment. This is another case where I don't have discovery.
January, it was January 29th, 2026, 9 AM, bond continued.
Thank you, Your Honor.
Court calls the case People versus Keith Moore.
Assistant Public Defender Nick Bukovich, but on behalf of Mr. Moore, who should be appearing via Zoom.
Keith Moore,
Yes.
turn
Hi,
on your
Your Honor.
camera. State your name.
Keith Derek Moore.
Thank you. What are we doing?
Your Honor, today is the day set for competency review as well as a PCC.
Probably cause hearing.
Is the court proceeding for competency findings?
Yes. I am now, I think, from
It is dated on November 24th, 2025. So it'd be after the last,
November 19th.
I'm sorry, November 19th, I'm sorry.
Yes, that's when it was completed. The defense counsel received November 24th.
I apologize, Your Honor.
No, it's okay. All right.
It does find that he is competent to stand trial.
Yes.
Would stipulate to its entry and have no further evidence.
Yes, and the defense would also stipulate to his entry, have no further evidence, and be requesting for adjournment of the PCC for the purposes of negotiation.
All right. Court having reviewed that report, court would find that the defendant is competent to stand trial, specifically that the defendant can understand the nature and the objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent, and I've signed an order to that effect.
In Your Honor, in setting the date, I have been in contact with my client's caseworker. He does have a civil court date on the 22nd, which I know is a Thursday. So I'll be asking for a PCC date that would align with that court date down at the 22nd Circuit Court.
29th, January 29th, 2026, 9 AM, bond continued.
Thank you so much, Your Honor.
Your Honor, if you said I missed it, does the court have a copy of an order?
Yes.
Oh, perfect. Thank you so much.
Excuse me, Your Honor.
Yes.
What's the civil court case?
What is what?
What was my civil? He said I had a civil court case.
Yeah, I have no idea.
I didn't have.
Speak to your
I had no
caseworker, Miss Bishop. She was the one who reached out to me to let me know about the court date. So you can so we could schedule this one outside of that, okay?
Okay, thank you.
I was asking
Court
for.
calls case, People versus Melinda Olivo.
Stephanie Canna on behalf of Ms. Olivo, who is approaching. Ms. Olivo, when you are present, please state your name for the record. Melinda Olivo, sorry. And Your Honor, we're asking for an adjournment. On this case, I have no media. So I would ask,
You have no media?
no, I have none.
Probable cause conference, January 29th, 2026, 9 AM, bond continued. Court calls case of the People versus Micah, is it Addison?
Signature on behalf of Micah Otteson, who appears on Zoom. And
It's
Your
Mika
Honor,
Addison.
oh yeah, I'm sorry. Mika Otteson, apologies.
It's what?
It's pronounced Mika Addison.
Oh,
Sorry.
you just wanted to yell at me, didn't you?
No, I really didn't.
See, if I had said Micah, if I had said Mika, she would have said it's Micah. No, I know what's going on here. I know what I'm being set up.
I hate
Go
my name
ahead, what are
sometimes.
we?
That's my fault, Your Honor.
No, it is your fault. You should have known.
Oh, I addressed her by her last name and I just haven't used the first.
Oh, you just skipped the first name because you didn't know?
Well, I just.
That's what I'm gonna do.
Ms.
I'm
On,
not-
anyway,
least
I
you said
should have
Addison
checked the first name. We're requesting an adjournment for 3 weeks just to provide some mitigation to the prosecutor.
Prosecutor's office, all right. Probable cause conference in this case. I'll adjourn it to November 29th, or not November, January 29th, 2026, 9 AM, which it seems like I'm setting. setting them that far. Court does call the case, People versus Riel, Page, Pollard.
Assistant prosecuting attorney for the proceeding.
Assistant Public Defender Donald Lee on behalf of Mr. Page Pollard, who appeared as via Zoom.
Here. Pardon? Sir, unmute, state your name.
Riel Page Pollard.
And Your Honor, we're requesting an adjournment. I did finish receiving discovery yesterday.
Probable cause conference, January 22nd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Hubert Price.
Assistant Public Defender Chelsea Reveals with and on behalf of Bert Price, who should appear via Zoom.
We don't have them.
I apologize, when I talked to him yesterday, he told me that he was fully versed on how to use Zoom. Would you mind passing it so I can call him?
Is it him? What's your name?
Hubert Price.
Your Honor, we are asking to adjourn this case for media discovery.
Discovery issue, January 29th, 2026, 9 a.m. Need a green sheet, bound continue.
Thank you.
Court does call the
Happy
case.
hol-
Thank. Pardon?
I said, thank you and happy holidays.
And to you, sir. Thank you. Court does call the case, the People versus Joanna Reed.
Assistant Public Defender Jay Bellinger, on behalf of Ms. Reed, who is on Zoom, Your Honor. There she is.
No, Ms. Reed. This is a competency.
That's correct, Your Honor. I did submit a finding in order to the court. The defense has no other, we would stipulate to the findings, we have no other evidence to present.
Also, so stipulate no further evidence.
All right, based upon a review of that report, court would find that the defendant is competent to stand trial. Would further indicate that the defendant can understand the nature and the objects of the proceedings against her and can assist in her defense. Therefore, the defendant is deemed competent, and I have signed that order.
Thank you, Your Honor. As to the PCC for this matter, Your Honor, we are asking for a new date. It looks like we're going to be able to reach resolution on this, so.
So January 29th, 2026, 9 a.m. Bond continues.
Thank you very much.
Thank you. Thank you, ma'am. Court calls the case, People versus Connor Rice.
And Alex Warren Green on behalf of Mr. Rice.
Your name?
Connor Rice. Your Honor, we're asking for a preliminary examination.
Discovery is complete.
I believe so, Your Honor.
People be ready. Will people have their witnesses available the 13th? Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Bond will continue. Thank you.
Thank you. Thank you, Your Honor.
Court calls the case of the People versus Montrez Root.
And Alex Warren Green on behalf of Mr. Root.
Where's his pants?
I got in from Phoenix, so I don't have them. I live in Phoenix, so I don't have them in my car.
Sorry.
It's all right. My bad, sure.
Did you fly?
Yeah, I flew in and then got here on right before Christmas and then I.
Didn't the people on the airplane tell you what the temperature here was? Even before you left Phoenix?
Well, I didn't. I came to I turned myself in when I got here because of the Warrant situation. So I was just trying to get here and get it over with.
Oh.
He'll have a pair of pants at the next court date.
No, you know what? If you do that and you're out there in that weather and that, have at it.
No, that was one of the things I was gonna ask today. If
what, for pants?
No, if it was a possibility, if I could go back to just get some of my clothes for my next court date, so I'm not looking crazy. if you would allow me to.
Go back where?
Phoenix, that's where I reside. That's where I live.
Oh. Do you have long pants?
Yeah, I got a lot.
Oh, okay, I didn't know.
Your Honor, with respect to
He knows
the-
you can buy them here too. Never mind.
I'll point him in the right
That's not
direction.
I'm not my business. Back to Amazon and bring them to you.
To Your Honor.
Never mind. Again, not my business. What do you want to do?
With respect to the probable cause conference, I would ask for an adjournment so that we can complete discovery. And I understand that my client is potentially going to be retaining a private attorney.
Mr. Vincent, I did this morning already. I just have to stop by his office before I head to where I'm going. But I already did.
Does he know you're in shorts?
Yeah, we spoke out. We spoke in the hallway when
What
we
did he
talked.
say?
He was ready for me. He said he was gonna try for me to get back so I can get.
No, what did he say about the short?
Oh, he didn't say nothing.
He did?
Okay, yeah. He didn't care. He was just happy that I was paying him.
Yes. Yeah, that's pretty much Michael for you. So you are retaining Mr. Vincent?
Yes, sir.
So I'll grant the adjournment, and that may be why Amanda's hanging around. What did we set as other things, Jim?
I believe the 29th.
29th. Okay, can you get to Phoenix and get back?
Yes, I can. I will. I'll have a nice suit on when I come back.
Oh, it's okay. I don't care. I'm just. That's all you brought?
Well, I got picked up in Phoenix, and instantly when I got to Phoenix, I had to wait in the county jail there because I didn't have a bond until I got here. So I had to wait there, and this is what I was driving, having a good time in shorts and hoodie. I didn't think I was going to jail.
No, I'm saying this out of genuine concern because he could walk out of here, his legs fall off.
Right. No, I have plenty of clothes back home.
Probable cause conference, January 29, 2026, 9 a.m. I will continue.
But I was thank you, Your Honor.
Tell Vincent, buy the man some pants. All right. Jeez. Clerk calls the case, People versus Thomas Sharon. Or Sharon.
Public Defender Chelsea Virgil is on behalf of Thomas Sharon, who I have not been able to get in contact with.
Thomas Sharon. Bench warrant will issue for defendant's failure to appear, bond set in the amount of 10,000, cash surety, that warrant will issue immediately. Court calls the case, People versus Ashley Shepherd.
Stephanie Cannon on behalf of Ms. Shepherd, who should be appearing by Zoom.
Shepherd,
Good
can you
morning.
state your name?
Ashley Shepherd.
We have reached an agreement in this case. It has not been reduced to writing yet, so I think we're just looking for a short adjournment to get that done.
Your Honor, that is correct.
Probable cause conference will be adjourned January 15th, 2026, 9 a.m. Bond continue.
Thank you so much. Ms. Shepherd, I will call you.
Thank you.
Court calls the case of the People versus Jordan Smith.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, who appears via Zoom, Your Honor. Mr. Smith, can you please state your name?
Jordan Smith.
And Your Honor, we are just asking, we have reached a resolution in this case that's contingent upon entry in the mental health recovery court. So I'm just asking for some time to get the application done. I will have that to the court by the end of the day. However, it may take some time, obviously, for the.
Right, on the other part of it, January 29th, 2026, 9 a.m. Bond continue.
Thank you very much.
Thank you, Your Honor.
Thank you, sir. Court calls the case of People versus Joseph Smith.
People.
Ashley Bashir on behalf of Joseph Smith, on both, this matter ending 1343 and 1915.
Joseph King Smith.
And Your Honor, this matter was previously adjourned to review discovery with Mr. Smith. We're requesting an adjournment for further negotiations or for negotiations on the matter to 3 weeks if possible.
Pardon?
3 weeks for both matters if possible.
Probable cause conference, January 29th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Case of the people versus Taj Smith.
Citizen prosecuting.
Asa Bashir on behalf of Taj Smith, who appears is on Zoom.
State your name, please.
Taj Smith. In your honor, it appears that there may be a conflict with our office in this case. The court would not have received documentation. It was very recently identified. We're requesting a 2-week adjournment just for new counsel.
Probable cause, January 8th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Calls case of people versus Kimberly Stampley.
Yes, this is Co-Defendant Intoxication from Ms. Lamprey, who is appealing via Zoom.
Hi, good morning, Kimberly Sampley.
All right. And are we doing the plea form?
Yes, we are, Your Honor.
So defendant is going to be pleading to 4 charges.
Yes, Your Honor.
Count 2 of operating with a high BAC, 180-day offense. Count 3 of operating without security, a 1-year offense. Count 4, fingerprint refusal, a 90-day offense. And count 5, attempted resisting and obstructing a police officer, 1-year offense. Upon our successful plea to counts 2, 3, 4, and 5, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor. I understand this will be no contest, please.
Yes, no contest, please. Is that a correct statement?
That's correct, Your Honor.
All right. Ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name for the record.
Kimberly Stampley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 4 misdemeanor charges. The first being count 2 of operating with a high BAC. That's a misdemeanor punishable by up to 180 days incarceration at $200 to $700 fine plus court cost. The court could order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized or forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes,
All right. Count 3 is operating without security. That is a misdemeanor punishable by up to 1 year incarceration, 200 and a fine not less than 200 nor more than $500 fine plus court costs. You understand that?
yes,
Also, that you'll be pleading to count 4, fingerprint refusal. That is a misdemeanor punishable by up to 90 days incarceration, a $500 fine plus court costs. You understand that?
yes,
And also an added count 5 of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. You understand all of that?
yes,
Do you understand what a no contest plea is?
yes,
2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these 4 charges. You understand that?
yes,
The second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
yes,
Basis for the no contest plea.
Correction, Your Honor.
All right. Do you still wish to plead no contest, ma'am?
yes,
To the charge of operating with a high BAC, how do you plead?
no contest,
To the charge of operating without security, how do you plead?
no contest,
To the charge of fingerprint refusal, how do you plead?
no contest,
To the charge of attempted resisting and obstructing a police officer, how do you plead?
No contest.
And you understand that by pleading no contest, you will not have a trial of any kind.
Yes,
You went over an advice of rights with your attorney and gave them permission to sign on your behalf.
yes.
Do you have any questions regarding any of the rights on that form?
No, I just want to say that I submitted the fingerprints. So,
Okay. Do you have any questions regarding any of the rights that are on the form?
no,
You understand that by pleading no contest, you're waiving or giving up those rights, particularly your rights contained under paragraph 5, your trial rights.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will.
yes,
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 24-11379. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these 4 charges. Ma'am,
yes,
if between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would first of all not be entitled to withdraw your plea, and secondly, the court would not be bound by any sentence evaluation or recommendation. You understand that?
yes,
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Court satisfied.
The defense is satisfied, Your Honor.
Court will accept the defendant's plea of no contest to counts 2, 3, 4, and 5. Count 1 is dismissed. A pre-sentence investigation and screening assessment is ordered at 14A1. Sentencing will be February 11th, 2026, 9 a.m. Bond in this matter with its conditions will continue.
Thank you, Your Honor.
Thank you.
thank you, Your Honor.
Thank you, ma'am. Court calls the case, People versus Sergio Staple.
People.
Assistant Public Defender Davi Lebo, we have Mr. Staples, who I believe appears on Zoom.
Mr. Staples, state your name.
Sergio Staples.
What are we doing?
Your Honor, Mr. Staples would like to waive. We do have an agreement where upon waiver and offer to plead guilty to counts 3 and 4 under HYTA as the court would be available. I do have the waiver form in front of me, and Mr. Staples, may I sign this with your permission, sir?
Yes.
Sir, you're waiving your right to a preliminary examination?
Yes.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yep. Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Your Honor, we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be set for
February 25th at 1:30 before Judge Conlon.
February 25th, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Bond continues. Thank you.
Thank you.
Court calls the case, People versus Brandon Thomas.
So what that
This is the prosecuting attorney for the people.
Assistant Public Defender Chelsea Ridgewood, with and on behalf of Thomas. Please state your name.
Brandon Thomas, Your Honor.
And we are asking to adjourn in this case for a plea discussion.
She's still testing positive.
For marijuana?
Yeah, you have a card?
I don't have a card, but I smoked before you took me to jail.
Oh, I know.
Yeah, so it's like
So the
My
numbers,
levels will be lower for sure.
so the numbers will be going down?
Yes, sir.
You sure?
Yes, sir.
Cause I can call over and get that.
Yes, sir.
Before I deal with it, he can have a seat. Can you call over and get those for me? Have a seat, I'll call it up. Cause if they're not going down, he's going right back. Court calls case, People versus Willie Thorne.
Prosecuting attorney for the people.
And Alex Warren, Green on behalf of Mr. Thorne. Mr. Thorne, could you please state your name for the court?
Willie Thorne. Thank you.
Your Honor, I'm asking to adjourn this case so that we can complete discovery and continue our negotiations. I've been in correspondence with the people. They indicate that the outstanding discovery is being sent over to us.
It's correct, Your Honor. Created the discovery packet with the meeting notice. It should be sent to the public defender's office.
January 22nd, 2026, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus India Tootle.
People.
Alex Warren, Green on behalf of Ms. Tootle.
Thank you, Tootle.
All right, what are we doing?
Your Honor, I'm asking to adjourn this case to continue negotiations with the people.
Probable cause, January 29th, 2026, 9 a.m. bond continued.
Thank you, Your Honor. All right, see you, Andy. I'll be in touch.
Court calls case, People versus Allen. Tremue. Yes. Here, sir, unmute, state your name.
Alan Eugene Tremue Jr.
And Your Honor, we're requesting an adjournment for negotiation on this case, just for further negotiations.
Probable cause conference, January 22nd, 2026, 9 a.m. bond continued. Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus Anthony Walker Ross.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Walker Ross, who should be appearing via Zoom.
Anthony. State your name and get someplace seated.
Anthony Walker Ross.
Yana has handed you a green sheet to say ask for some time for pre-negotiations.
Probable cause conference, January 29th, 2026, 9 a.m. bond continued. Thank you. That is.
Yep, I got it.
Court calls case, People versus Willie Wallace.
Assistant Prosecuting Attorney for the people.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Wallace, who should also be appearing via
Yes.
Zoom.
All right, need a camera. What are we doing?
Okay.
We'll be requesting a sentence.
Okay, there we go. Oh, yes.
All right, thank you. What are we doing?
We'll be requesting a sentence matter for preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available the 13th.
Don't see any reason why we would not.
Preliminary examination in person. January 13th, 2026, 9 a.m. That's before 15th District Court, Judge. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls case of the People versus Ashan Wasim.
Brian Bowling on behalf of Mr. Wasim. Proceedings. State your name for the record, please.
It's not Wasim.
Speak up. You gotta.
Oh, it's not Wasim.
hear that, Your Honor. Your Honor, we're asking for an adjournment for additional plea discussions with respect to this case.
Probable cause conference will be adjourned January 22nd, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Thank you.
Have a nice day. Happy New Year.
Court calls case People versus Kwan White.
Water System Prosecuting Attorney for the People.
Assistant Public Defender Ben Benoit, at Mr. White, who is appearing on Zoom. Mr. White, would you state your name for the record, please?
Kwan White.
He's logged in, Your Honor. Can I call him?
I don't know if you can or not, but he needs to be ready to go. Kwan White, prompt him. Kwan White. I'll pass it. Mr. Weidling, he's lost his privileges. He's not going to be able to appear via Zoom.
Yes, sir.
Court calls case People versus Mario Williams.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Williams.
Your name? Mario Williams. Thank you.
Your Honor, we're asking to adjourn this matter for further investigation.
Cause conference, January 15th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you.
Thank you.
Court calls case People versus Xavier Williams.
Water System Prosecuting Attorney for the People.
Ashley Bashir on behalf of Xavier Williams, who is approaching.
Xavier Williams.
Thank you.
And Your Honor, we're requesting an adjournment to review discovery that was provided by the prosecutor. I requested it yesterday and it was provided, so we just need to review.
Probable cause conference, January 22nd, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case People versus Jovial Wilson.
Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Virgil with and on behalf of Jovial Wilson.
You're so close.
What was it? What is it?
Jovial Wilson.
Yeah,
sorry.
I kind of said that.
Yeah, you almost started to have, then you just let it go, like, nope.
Wow. Wow, let's just come up, everybody about their first name swinging. Can't even just name him John. Be over with it. Go ahead.
Hey, at least it wasn't inaccurate, totally wrong.
True. All right.
Your Honor, we are asking for a very brief adjournment. I'm happy to report we do have the media in this case, but Mr. Wilson waited quite a long time for it. We would like to get this case moving along. We're asking you to consider a 1-week adjournment.
1 week,
I think that's enough time for us to review the
the
media.
paperwork for the clerk's office won't dry by then.
He's picking up the USB from our office today. I believe in us. We can do this.
Me too. No. She's so nice, so. She is. She always acts so nice and politely. There are people that can take a lesson.
I'm listening.
January 8th,
Your Honor.
2026, 9 a.m. Bond will continue that way. If he can get it done, I don't have to try to mispronounce his name anymore. All right.
Thank you, Your Honor.
Take care.
If I was about to go.
Huh? Okay, I don't know what those are. Court calls the case People versus Stephen. Is it Yenny?
Cash calls for the People.
Assistant Public Defender Chelsea Virgil with and on behalf of Stephen Yaney. Please state your name.
Stephen Yang.
And we are asking to adjourn this for however long the court prefers for media discovery.
So you're looking for more meat, oh, gotcha. Probable cause conference, January 29th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, sir. This, the facility did. Court does call the case of People versus Robert Watkins.
That's felt with people.
And Alex Warren Green on behalf of Mr. Watkins. Your Honor, I don't believe he's present.
He is not. The Jackson County Jail did not sign in if he's still there.
And Your Honor, since the last time his case was scheduled, I did review some records from Jackson County. He has 10 total cases there. His next court date is February 10th.
Jackson?
That's right. And it looks like what happened is he was transported over there on a couple of cases. And once he arrived, they authorized several other cases.
They've also filed HAB 4s on all of them that are felonies.
Yeah, 9 of the 10 are retail fraud firsts with a habitual fourth, and one of.
So you said that the last date of the ones that you see is February 10th?
On the only cases I saw in the circuit court system over there had court dates for February 10th. It looked like they were moving everything to February 10th in front of the Fourth Circuit judge.
Got it. So why don't I try to do this, and see if, once they get it settled, we can do this. I'll adjourn this to February 5th, 2026, 9 a.m. That way, maybe we can see if we can get them to appear. Thank you.
Thank you, Your Honor.
Court calls the case People versus Amber Cormos. Recall.
That's felt with people.
What was I doing?
This is Mr. Mill.
He's writing from Jackson.
My apologies, Your Honor.
Pardon?
My apologies, Your Honor. J. Grant Miller, P58658, on behalf of Ms. Cormos.
Where is she?
She is still en route, Your Honor.
From Jackson?
Yes, Your Honor.
I called this like.
Believe it was right around 10 o'clock the first time, Your Honor. I could be a little mistaken.
That's okay, even if ballparking it. 2 hours from Jackson?
She had to arrange to get a ride. She does not have her own vehicle.
To bond 10,000 cash surety. Or will issue immediately.
Your Honor.
Court calls the case People versus McCall. Yaquisa. Yeah, Yaquisa.
On behalf of the people.
Is he ready?
Yes, Your Honor. I did speak to him.
Think so?
I spoke.
All right, let's see what happens.
Mr. Keitha, could you please tell the court your name?
Miguel Urquiza.
And Your Honor, Mr. Keitha would like to address the court.
Go ahead.
So before the 15th, before I got tested, I was invited to a house party or a social gathering with my friends. And that's where I was offered THC, edibles, more like pastries. And I agreed on taking a chocolate cake, THC, and yeah.
So why did it take all this for you just to say all that?
You're right, and that's my apologies.
Your Honor, I think it really comes down to fear and naivety.
Of what?
Naivety.
No, I get that, but. I don't know how naive you have to be to come before a judge and just start lying. I don't even get that.
Quite naive, Your Honor.
He said, who's here with him?
His parents are both here, Your Honor.
Those are his parents?
Yes, Your Honor. I did speak to them in the hallway and I did see them out in the gallery.
Proud moment, I'm sure. Hello, I see. You guys came from Chicago? You kind of heard what he did. I won't ask Dad. Mom, you want him back? You want him back? You do? Okay, because I don't know what Dad to say. You want him back too? Oh, interesting. So, young man, I know they didn't teach you to act this way, right? They did not teach you to go around lying about everything. Did they? Let me just ask you one more question. Prior to you getting locked up, did your parents know you were in trouble?
My father did. My father, he's the one that he attended here, before I got locked up.
I'll reinstate the previous bond, $10,000. Personal recognizance. I'm gonna let him go.
Thank you, Your Honor.
Young man, life gets a whole lot easier. It stays a whole lot easier. Just tell the truth. Pay the consequences for what you did and just deal with it. And you don't have to go.
Thank you, Your Honor.
Thank you.
Have a good holiday.
You do the same. Case of the People versus Edward Poe.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Attorney Kevin Bassan, P71061, on behalf of Mr. Edward Poe. Mr. Poe, state your name for the record. Edward Poe.
Thank you.
So, Judge, today's date and time scheduled for preliminary exam. The defense counsel, we're prepared to proceed, Judge.
And that is correct. It's a daytime set for examination. The one witness and officer in charge, Deputy Ward, let me know that he is on scheduled vacation. He's off this week. He's on. I would be asking for a brief adjournment. That's why I understand it. That's not the court's decision.
And Judge, just for the record, defense counsel, we will move for dismissal, Judge. I believe the people have had more than enough time to secure their witnesses for this particular exam, Judge. Again, I'm not the people, Judge, but I'm not even certain how much.
You want to keep going when you're winning?
Thank you, Judge.
I've been saying that all day to people. They just, I don't know. It's my friendly face. People want to talk to me. Yeah, maybe. All right. People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you very much, Judge.
All right. Thank you, sir. Have a good day. Yes. Court calls the case People versus Samuel Allen Dabney.
Ready, Judge.
Good afternoon, Your Honor. Warrant on behalf of the people.
Good afternoon, Judge. Attorney Kerry Mitchell appearing on behalf of my client Samuel Allen Damon, who's approaching to my right. Today's the date set for a preliminary examination, Your Honor.
Nope, right here. Nope, switch.
That's right. Yeah. All right. Today's the date set for an exam, Judge. We're going to waive that examination. My client understands that he has a right to a preliminary examination, and that if an examination was held, the people would have to show that a crime was committed and that he probably committed that crime. He wishes to waive those rights.
I did discuss this with defense counsel, and we discussed that I would be filing an amended information with the corrected counts. May I approach with that information.
That is correct, Judge.
So
So he would be waiving as to counts 2 and 3, and count 1 would be dismissed. Counts 2 and 3 are child sexual abuse of material, aggravated possession, the 10-year felony.
And
okay, I
20-year
see.
felony.
Yeah.
is being-
So he's the original charge. Let me go to
With 75145C2, which is a 20-year felony, Judge.
I got that.
Oh, okay.
So I'm just going on the count. So count 1 is going to be dismissed. He's waiving up on counts 2 and 3.
That's correct, Your Honor.
That's-
All right.
That is correct.
You understand that, young man?
Speak up.
Yes.
All right. And you understand that you're waiving your right to a preliminary examination where the people would have to show by the standard of probable cause that these offenses were committed and that you committed them.
Yes.
Okay, and you understand you're not going to have that hearing and you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Your Honor, as to the matter of bond,
Oh, hold on a second. Preliminary examination having been waived, defendant is bound over to circuit court on counts 2 and 3. Count 1 is dismissed. Yes, go ahead as to bond, but as to the circuit court arraignment, you waive formal reading of the complaint
yes, Judge.
or the information. Stand mute at this time.
Yes, Judge.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
January 15th at 1:30 with Judge Lynn.
January 15th, 2026, 1:30 before Judge Slay. Yes, as to bond.
Your Honor, as to the bond, I believe that the bond is really excessive. It's 500,000. Based upon the amended charge, which is basically half of what he was facing. I believe an appropriate bond, and also my client has no prior criminal history whatsoever. I would respectfully ask the court to place a more reasonable bond considering the circumstances. I believe, I'm not asking for a personal bond, Judge. I respectfully ask the court to give him a bond, possibly 25,000, 10%. 500,000, I believe is really accessible. I don't know if the court remembers, they probably had 1,000 other cases since I last argued.
No, I remember you.
Oh, okay.
And maybe that's a good thing or a bad thing, but
Yeah.
I remember.
Well, I was hesitant because I gotta catch a plane tomorrow. I don't want to get locked up today, so otherwise I wouldn't mind, but.
Well, maybe they'll hold the plane for you if you keep on.
May I?
Yes.
I would object to a change in bond. I did, Detective Morrison from Washington County is the officer in charge of this case, and I did speak with her today. She did a review of Mr. Allen Dabney's phone, and both in the report and in my conversation with her said that he had an overwhelming amount of child sexually abusive material on his phone. And it was accessible by her, not a forensic analyst, just in reviewing his phone. He had an overwhelming amount of both images and videos, and prepubescent children. I think given that this bond is appropriate.
Yeah, I'm not going to go
Go ahead.
into everything that I said before. He was in a relationship with an individual. This individual, I believe that given the circumstances and the bond is just really excessive. I don't want to get into the other underlying facts about, and the people know that this other person that was the target of this investigation is the main character in this situation.
Let me ask this. And I understand that there have been a change in charges. I also know that sometimes when that happens, when there's a waiver up, it's a waiver up on 2. But given what would be this overwhelming amount of stuff, and again, I don't know what that is or necessarily quantifiably means, could there be potential other charges?
I mean, certainly.
I mean, I'm not suggesting it, I'm just trying to get a
Yeah,
feel
I
for
think,
it.
it was
Yeah.
not, in my viewpoint, charged correctly at the outset. And so part of this was to ensure that he was waiving up on the correct charges. But yes, I mean, he's waiving up on counts 2 and 3, but technically every image, or photo or video that he had could be another charge. So the answer is yes. As to like a different charge, I, at this time, don't think so. This did originate as a Canton investigation into, yes, correctly, a wider ring of people of which the defendant was part of. And he was residing in Ypsilanti, so that's why this case is.
And
We're
just
saying.
briefly, Judge, the person that he was involved with that originated in Canton, those individuals were referred to the federal system and they were prosecuted in that realm. He is the only one that was not, and that is because he was not, in their opinion, a main character in this.
When you say they're the federal.
Correct.
Okay.
Correct, Judge. So, and I'll get into this when it gets to circuit court, but in relationship to them being on his phone, this other individual that got charged federal had access to my client's phone.
Having heard everything in this, I will reduce the defendant's bond. I'm going to grant the motion in part, but not nearly to the extent that the defendant wants to reduce. I'll reduce his bond to a $250,000 cash surety bond.
Court consider 10%.
If I would have said it.
Okay, well, I want to catch that plane, Judge.
Yes. You're doing everything to not, but no, I will not consider 10%. Thank you.
Have a good day.
Court calls the case, People versus Merlin Bement. That's what? Oh, that's the recall. Is the I just want to make sure it's working. Did Ken let you know? Is it working?
Yes.
Okay.
And I can see it. Gonna wait till.
Okay.
Ashley Feltus for the people.
Assistant Public Defender Ben Denowith for Mr. Bement, who stands to my right. Can you state your name for the record? What's your name? Okay. Would these headphones help you? Can you hear a little bit? Okay. You want to try these? No, okay. Your Honor, we would like to set this matter for exam.
You have all of the discovery,
Yes, Your Honor.
and would the people have their witnesses available
We will
the
try.
13th?
The 13th?
Preliminary examination in person will be set January 13th, 2026, 9 a.m. before a 15th District Court judge. Bond will continue.
Yes, may we address bond, Your
You
Honor?
may.
My client is 69 years old. I looked him up in X jail. The only thing other than this case was a trespass warrant from 2011, which means he hasn't been arrested since 2011. I looked at his HYTA, and that was clean. I don't know if he has out of state or suppressed cases, but it looked clean as far as what I can get. I'd indicate to the court, his current bond is $500 and he can't make that. We'd ask the court to reduce that to a PR. This is a single witness case, no weapon was recovered, and there's no video. Mr. Bennett is experiencing homelessness, but he's fine with staying at the Delana Center if the court would allow it, and he's being 69 years old, he's obviously retired.
Your Honor, the defendant has extensive out-of-state history from Florida and California, dating back almost 50 years to 1977. Of course, I can't see all of the charges as clearly as I would be able to if they were in the state of Michigan. But what I was able to review showed an extensive assaultive history, including what was literally strong arm rape, I believe, as one of his cases. Assaultive cases as recently with arrests in 2024. I do not believe he has strong ties to this community, so I would consider him a flight risk. I also think that he is a danger to the community should he be released. This case involves an allegation of him threatening someone with a knife. And I would ask the court to continue the bond as set. It is frankly much lower than our original request.
Anything else?
Nothing else for the court. I guess I could ask the prosecutor to, at some point in the future, potentially send me the information on the record that the defense does not have, but that wouldn't have to be today.
I'm going to deny the request at this point and continue his bond as it said. I think it's appropriate. And certainly it can be raised on the 13th of January.
Thank you, Your Honor.
Thank you.
We're in front of Your Honor on the 13th?
No, 15th, whatever that might be. Court does call the case, People versus Jimmy Lee Perry.
Andrew Childers, on behalf of the people.
Good afternoon, Your Honor. Robert Ellman on behalf of Mr. Perry. Your Honor, today's date and time set for exam. As you may recall, you authorized Mr. Perry to be allowed to attend inpatient treatment. I was notified yesterday that he was taken to treatment from the jail to Sacred Heart in Richmond. They have informed me that they do not allow Zoom court procedures or any other way to facilitate him being here today. So he is not here. I do have proof of that treatment if you'd like to see it.
No, I believe. How long is
so the program maximum is 30 days. In what they sent me, they said their average time of attendance is anywhere from 10 to 21 days. So I'm not sure exactly. It's going to depend on how well he does while actually in treatment.
Well, why don't I do this? Why don't I adjourn it to my next date, which is the 13th, and if we have to go to another date, we can do that.
That's fine. Mr. Ellman let me know yesterday, so I could call off my witnesses.
So preliminary examination in this matter will be adjourned to January 13th, 2026, 9 a.m. That's before me.
Thank you, Your Honor. That's it for me today. So have a happy new year.
Yes, and to you, sir. Court calls case People versus Corey Curtis.
Good afternoon, Your Honor. Raymond Cook, People.
Good afternoon, Your Honor. Alexandria Taylor appearing on behalf of the defendant Corey Curtis, who's approaching. Mr. Curtis, please state your name for the record.
Corey Curtis.
This is the date time set for preliminary examination. After conversation with the counsel, we're going to humbly, respectfully request that this court adjourn this exam. There is
humbly. So that humble was coming from you or from defense counsel?
From defense counsel. She's more humble than I.
Oh, I knew that. That's why I was curious as to where it was coming from. Go ahead.
There's been an offer that was extended as well as some additional conversation as well. One of the people's necessary witnesses for staff, My understanding is he is away serving in the military right now and could not be present today. He could be present via Zoom if the court would allow that. Otherwise, I expect him to return, I want to say at 1 to 2 months, I believe is when it was expected to return.
Okay.
So that is correct, Your Honor. We have discussed the date of February 3rd on Your Honor's docket, if that pleases the court.
Man, why are people picking my date? What, is that my day? It is? Did you tell him? Somebody gave him my date, because it's a secret. Okay, it's not a secret. People aren't supposed to know when I'm here or not. So February 3rd.
Yes, Your Honor.
Yes, please, thank you.
All right, I'll do it, only because defense counsel humbly asked.
Thank you, Your Honor.
Preliminary examination will be adjourned February 3rd, 2026, 9 a.m. That is before me.
Thank you, Judge.
Thank you. Bond will continue.
Thank you.
Your Honor, just, I'm where, can I get the Zoom?
Did you just leave and your case isn't over yet? You say, ooh, my bad. He said it was, so he just turned his back to me and walked out. His attorney had talked to him about that.
We'll have a
If
discussion.
Trooper Sass will need to appear via Zoom. Can I get that Zoom information from Ms. Whiting when we get a little bit closer to that date? or not?
Yes, if it's going to be necessary, certainly you can get that from me and
Thank you.
we'll provide that.
No objection to Zoom.
Very good. Thank you. Now you may go. Court calls the case, People versus Joseph McCallum.
Good afternoon, Your Honor.
Counsel have another one. Did you have another one, counsel? She does.
It's this one.
That one. Oh, okay.
After, okay.
Yeah.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. McCallum. State your names.
Yeah.
Joseph McCullough.
Okay.
Your Honor, the defense side, we're going to examine this and then people are unable to proceed.
And the defense would move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice on the defendant's motion.
Thank you, Your Honor.
Thank you. Court calls case, People versus Nikita Jackson.
Good afternoon, Your Honor.
Good afternoon again, Your Honor. Alexandria Taylor appearing on behalf of defendant Nikita Jackson, who is approaching. Ms. Jackson, please state your name. Nikita Jackson.
Thank you.
And Your Honor, similarly on this case, we're respectfully requesting an adjournment. We can get that same date in order to keep the cases together. People would appreciate that greatly.
Does that sound humbly? I bet you, if she told me, I'd probably feel like really warm. Cook, he just rubs me the wrong way. I will adjourn. Preliminary examination will be adjourned to February 3rd, 2026, 9 a.m. And that is before me.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you.
Happy New Year.
And to you. Court calls the case of the People versus Raul Fernando.
Andrew Childers appearing on behalf of.
Good afternoon, Judge Aida Sparhich on behalf of Mr. Raul Fernando, who is approaching and now standing to my right, Judge.
Your name, sir? Raul Fernando. Thank you.
Today's the daytime set for examination. This is some people will be moving to dismiss this case without prejudice, filed and non-impossible.
No objection on our end, Judge.
Case is dismissed.
Thank you, Judge. Happy New Year to you and your staff.
And to
Steve.
you. Court calls the case of the People versus Robert Jameson.
Good afternoon, Your Honor. Raymond Cook, the people.
Good afternoon, Your Honor. J. Grant Miller, P58658 on behalf of Mr. Jameson.
Where is it?
The daytime set for preliminary examination. I believe Mr. James had a PCC earlier today, the court issued a bench warrant. In full candor, the people were not able to proceed today.
Full disclosure to the court, Your Honor, I discovered at about noon that Mr. Jameson actually had gotten released from custody and missed his morning court when I went to try and
Yeah, my
visit
staff
him.
was telling you that time and time again, but you weren't listening. But go ahead.
Well, Your Honor, I just wanted to verify it with all the.
Yeah, no. My staff was telling you. You know, and it's a funny thing. I have the greatest staff in the world. And they tell you something. 99.9% of the time, they're right. You can take it to the bank because quite frankly, I trust them more than any other people running around this planet. And when they tell me something, I take it to the bank. You might want to learn that, counsel. Bench warrant will issue in this case bond $25,000 cash surety. That warrant will issue immediately.
Thank you, Your Honor. The only other part I was going to add is I also have no contact information for Mr. Jameson. So if he is picked up, I'd ask if the court could, maybe try and get a phone number or something for him. I assume he'll be in custody.
Well, the magistrate, they'll do what they can.
Thank you, Your Honor.
Thank you. Court calls case, People versus Yasina Miranda.
Good afternoon, Your Honor, Raymond Cook, people.
Alex Warren Green on behalf of Miss Miranda.
Your name?
Yesenia Miranda.
Okay, I almost got it right. Say it again. the first
Yesenia
name?
Miranda.
Okay, all right. Because everybody's been yelling at me because I mispronounced people's name all day. So I'm a little sensitive.
Your Honor, this is the date and time set for preliminary examination. This time people are unable to proceed. Counts 2 and 3.
The defense would move to dismiss, Your Honor.
All right, are you moving to remand on counts 2 and 3?
Yes, Your Honor.
All right, then what I will do. I'll continue the defendant's not guilty plea as to counts 2 and 3. Count 1 will be dismissed on the defendant's motion. I'll set a pretrial on this matter. January 22nd, 2026, it's at 9 a.m.
Yes.
9 a.m. before Judge Washington. Brownie will continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Derek Shipman.
Brian Bowling on behalf of Mr. Shipman, who's approaching, Judge. Hey, Derek, state your name.
He knows it.
Derek Shipman.
Thank you.
Judge, we have a resolution in this matter. There should be a signed plea form in the court file as well as a signed advice of rights. Or a advice of rights I signed on Mr. Shipman's behalf with his consent.
All right. The plea form indicates that the defendant is going to be pleading no contest. Did I get this, please? Yeah, I did. No contest to 3 charges. Count 2 of operating while intoxicated, the 93-day offense. Count 3, driving while license suspended, a 93-day offense. And count 4, disorderly person, a 90-day offense. Upon his successful plea to those charges, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's my understanding as well, Judge.
May I have him sworn?
You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Derek Shipman.
Sir, it is this court's understanding that you're going to be pleading no contest to 3 charges. Is that your understanding?
Yes.
First charge is count 2 of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail. A $300 fine plus, or I'm sorry, a $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order your vehicle forfeited, or could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
All right. Count 3 is the offense of driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that, sir?
Yes.
And count 4, disorderly person is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes.
All right. You understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Valvo in the 15th District Court?
Yes.
All right. Or her successor, I should say. Still wish, and the basis for the no contest plea count?
Lack of recollection, Judge.
All right. Still wish to plead no contest, sir?
Yes, sir.
To the charge of operating while intoxicated, how do you plead?
No contest.
To the charge of driving while license suspended, denied, and or revoked, how do you plead?
No contest.
And to the charge of disorderly person, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or had an advice of rights form signed on your behalf?
Yes.
All right, any questions regarding any of those rights?
No.
You understand that by pleading no contest, you're waiving or giving up the rights on that form?
Yes. Oh, excuse me. Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
Yes.
Okay, were you on probation or parole at this time?
No, sir. No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
All right. Court has been provided and has reviewed Ann Arbor Police Department report for their case number 24-3152. Any objection to the court having reviewed that report?
No objection.
No objection for the defense, Judge.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation and recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have?
I'm not aware of any, Judge.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
So is the defense, Judge.
Court will accept the defendant's no contest pleas to counts 2, 3, and 4. Count 1 is dismissed. A pre-sentence investigation and report is ordered, as well as screening and assessment at 15th District Court probation. Sentencing in this matter will be January 20th, 2026. What time? 9 a.m. Before Judge Valvo or her successor. Bond will continue.
Thanks, Judge. Thank you, sir. Happy New Year.
And to you, sir. Court does call the case, People versus Abbas Safadine.
Andrew Childers, appearing on behalf of the people.
Good afternoon, Your Honor. Jonathan Sachs for Mr. Safadine.
Boss Deputy, Your Honor.
All right, thank you. All right, what are we doing?
We are here for a negotiated guilty plea.
All right, I have a plea form before me indicates that the defendant will be guilty to the charge of larceny by false pretenses under 200, 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed. There is also the agreement that the prosecutor will recommend or is okay with the HYTA sentence, and restitution is agreed at $500.
That's correct, Your Honor.
Okay, the sentencing judge waiver box is not checked, but I view that as an oversight, so I'm going to check that box.
That is purely my oversight, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear in front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Boss Deputy.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the offense of larceny by false pretenses under $200.
Yes, Your Honor.
That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property, which is the subject matter of the false pretenses. If that's greater than $500, that becomes the maximum fine. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this matter, and you would be sentenced before Judge Perry in the 15th District Court.
Yes,
You
Your Honor.
understand that?
Yes, Your Honor.
Understanding all that, still wish to plead guilty?
Yes, Your Honor.
All right, and to that charge, how do you plead? How do you plead?
What do you?
Guilty or not guilty?
Oh, I plead guilty.
Yeah, right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct, sir?
Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No,
to do it? Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
March 16, 2025, at the location of 516 East Liberty Street, City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do regarding, or what'd you do that makes you think that you're guilty? Let's do that.
I used the card that was on mine to pay for the parking structure.
To do what?
To pay for the parking structure.
Okay. So the card was not yours?
Yes.
You didn't have the owner or device holder's permission to use it?
No, I just did.
And you did not inform wherever you were using it that you didn't have permission?
No.
Right? And because of your use, you obtained goods or services?
No.
You didn't get anything?
No.
What happened?
Your Honor, it was rejected, but he still used the financial
Yeah,
transaction.
got it. Okay, but he didn't get anything from it.
No.
Okay, then I'd have to certainly take it as to the higher charge, which is actually the use, because there was no value done. Okay. Sir, if I accept your plea, I do have to advise you that between the time of my acceptance of your plea and your time of your sentencing, that if you commit misconduct as defined by the Michigan court rules, that number one, the court would not be bound by any evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea to count 2, particularly under the higher offense version. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be January 30th, 2026, 8:30 before Judge Perry.
Your Honor, is there any chance of another date? I'm looking forward to being right here on January 30th at 9 a.m.
Oh, I'm sure there's another day. I don't have it. So what you can do is I have to give you this date. You can contact 15th. They'll be more than happy, I'm sure, to accommodate another date.
All right, thank you.
Thank you. Court does call the case. People versus Trevor Howard.
Good afternoon, Your Honor. Kate Resourcey for the people.
Assistant Public Defender Ben Dunn on behalf of Mr. Howard, who is standing to my right.
Time and place scheduled for prelim, and unfortunately, people are unable to proceed in anticipation of a motion to dismiss the felony counts and seek a remand on, I believe it's count 4, Your Honor.
Yes, it would be count 4.
And we would make that motion. We don't have a legal argument against the remand, but we would like to address bond, given that my client is now only charged with a misdemeanor.
I'll continue the defendant's not guilty plea to count 4. Counts 1, 2, and 3 are dismissed. A pretrial date in this matter will be set
January 15th at 10:30 before.
January 15th, 2026. What time is it?
10:30.
10:30, of course, before Judge Freshour.
Thank you, Your Honor.
Is that A3 or A4?
Pardon?
10:30.
10:30.
Oh, I mean, the court.
That's actually A4.
Okay. And may we address bond, Your Honor?
Go ahead.
So Your Honor, my client works Monday through Thursday at Cushing Malloy Books. He works 410, so that's 40 hours a week. Then he additionally works at Hollywood Sales doing car audio Friday, Saturday, and some Sundays. So he is fully employed. He lives with his mother in Ypsilanti. He is her caretaker. She has cancer. That's on Clark Road over in Ypsi. And he does have a pretty limited criminal history, I would say. So we'd ask the court to release him to his mother's house, and the court can impose conditions as the court feels necessary, of course.
What happened? Well, there's a problem. Because the defendant initially had a personal recognizance bond, but then he violated. Yes, twice, but he definitely violated where the court felt it necessary to issue a no bond warrant on him. So what makes me think, even with charges where they are, that the defendant is going to be able to comply with bond conditions?
Well, I would say, you know, if the court thought he strangled the person, he's a lot more of a danger to the community than if he had committed misdemeanor domestic violence. Just because of the nature of the charge, I think if you're a person that would do that, you could be considered more dangerous than a person that commits misdemeanors. He's no longer charged with a felony. The witness apparently was not interested in pursuing the case. So I don't know what happened. I think as far as him violating bond, he's certainly learned his lesson. I don't think he's a frequent flyer here that has violated bond in the past or anything like that. So if the court would give him another chance, we think he would comply this time.
I don't really need anything from the people, but I'm just going to tell you, the defendant hasn't been able to comply with bond. It now becomes Judge Freshour's issue to deal with. And I'm going to certainly leave it to her to decide the conditions of releasing the defendant. So your motion for bond reduction tonight, bond will continue.
Thank you, Your Honor.
Charles case, People versus Terrence Weatherspoon.
Individual is appearing on behalf of the people.
Assistant Public Defender Ben Dunn on behalf of Mr. Weatherspoon, who is joining me at the podium now. And sir, would you state your name for the record, please? Terrence Weatherspoon. Your Honor, we've worked out a deal involving a waiver and a plea at circuit court in this matter.
Correct, Your Honor. My understanding is that Mr. Weatherspoon will waive his right to a preliminary examination. The people will not file a vigil in this matter. And in circuit court, there'd be an offer for a plea to an added count of possession of less than 25 grams of controlled substance.
We've got a problem. Mr. Allen. Have his bond violation?
I do. So, well, can I address it on the record, Your Honor?
Yeah, go ahead.
I talked to my client about it. His position is that he was incarcerated. And, you know, I think he admitted the first violation, to Your Honor. He denies this one, and he's paid, I believe it was $150 for the sample to be retested at a lab. So, given that the retesting is in progress, I'd ask the court to defer any action to Judge Conlon, and perhaps we'd have those test results back in 2 weeks, or I mean, if they came back later than that, I'm sure the government would be addressing it regardless.
Does he have a medical marijuana card?
No, I mean, I don't, that was why I had the, last time I asked you, I told you about the appointment, and that was the whole thing. So we trying to get a medical marijuana card right now. I got a doctor appointment scheduled on February 11th for all of this. In the cocaine drop, I don't see how it was positive, and I'm supposed to test today too, actually. So I'm trying to figure out how. I don't understand how was it dirty. That's why I paid for it to get tested again. They told me it'd take up to 2 weeks for it to come back from California, and regards to.
Well, maybe if that's the case, I mean, except that And here's the problem, counsel. I might wait, except that his last 3 tests have been positive for cocaine spanning from November 17th to December 26th. And then he had the THC positive in November, but then THC leaves his system and then he's back with THC in his system again.
I speak, Your Honor.
All right, if your attorney wants you to, I mean,
Don't talk about anything before November, but I
The-
think we're fine talking to the court about his substance abuse issues. He's pretty open with it. You know, he admits he has an issue. He's I'd just say to the court, I think THC opinions have evolved, and you know, I haven't known Mr. Weatherspoon very long, but he's pretty obviously in pain to me. Frankly, I think THC is better for a person than taking opiate pain relievers. He can barely walk. I mean, I think he needs.
that's good, doctor. I don't know.
He had a
I'm
doctor
trying to
appointment.
debate that issue. That's not it. And it may very well be, but that's why he needs to just get a card and then there isn't an issue.
I scheduled to make an appointment for the card. In the cocaine dirty, that's why the first time I told you, I said, Judge Simpson, I did that. This time I'm 100% sure I didn't do any drugs. So that's why I had it sent out for the test, because I know I can't be dirty for it. Would you allow me to take a test today to, like, I know I'm not dirty. I ain't using no drugs, man.
My name's not man.
Yes, sir. I'm sorry, sir, but I'm sorry, sir.
Just don't judge is good.
And if it comes back dirty, I just leave you in there forever.
Ever is a long time.
I
sir.
know, but we're gonna make a deal. Let's make a deal.
Let's make a deal.
Is that it?
Deal.
If you come back clean, then I get to decide what to do. Test. Let him know he's coming over to test.
Where's he going? Community corrections?
Community corrections.
All right. Obviously, if you don't come back, it's work out. So come back.
Court calls the case of the people versus Martinez Smith.
Good afternoon, Your Honor, Raymond Cook with the people.
Good afternoon, man. Please, Honorable Court, Kareem Johnson, appearing on behalf of Ms. Smith, who is approaching, standing to my immediate right.
Your name?
Martina Smith.
I have before me a plea form. Plea form indicates that the defendant is going to be pleading to count 3 attempted resisting and obstructing an officer. That's a guilty plea to 1-year offense. On her successful plea, counts 1 and 2 would be dismissed. And there's a sentence agreement of sentencing under HYTA. That's the court's full understanding.
That's correct, Your Honor.
Let's have her sworn.
Raise your right hand. Solemnly sworn to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes.
State your name, please.
Martina Smith.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer.
Yeah.
That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that? You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge pardon? Valvo or her successor in the 15th District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question about any of those rights? Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you're guilty of this offense? On the date of July 28th, 2025, at the location of 3205 Boardwalk, City of Ann Arbor, Washington County, State of Michigan, did you come into contact with officers from the Ann Arbor Police Department?
Yes.
And you'd admit they were in the lawful performance of their duties?
Yes.
How do you think you resisted and or obstructed them?
I didn't firmly put my arm behind my back.
Pardon?
I didn't firmly put my arm behind my back, strangled.
Okay, so they were trying to arrest you
Yes.
and they told you to put your arms behind your back
Yes.
and you resisted doing that?
Yes.
All right. Young lady, if I accept your plea, between the time I accept your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, court will accept the defendant's plea. Guilty to count two, count one is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
January 20th at 9 a.m. before Judge Bello.
January 20th, 2026, 9 a.m. before Judge Valvo or her successor. Will continue. Thank you.
Thank you, Your Honor.
Thank you, sir. Is that it for Mr. Johnson?
It is.
It is. Mr. Johnson, have a great New Year, sir.
Thank you too, Your Honor.
Answer from either side on what's happening on this one. This is holding. It is.
Oh.
Yeah, this is Katie.
Oh, so we don't know.
This is Katie. This is Mr. Miller.
Okay. Oh, got it. Okay, we'll do that. This is,
That is Ms. Rezmirski and Mr. Miller.
you know what we're doing on Riddle?
We're standing before the court unable to proceed.
I was waiting to see if the people had a witness, Your Honor.
We do not have a witness. No.
So it's amazing what conversation and talk will do. I'm just saying, what do I call that case?
Thank you.
See? I made your job easy today. I did. Because that's what my obligation in life is. Court does call the case, People versus William Riddle.
Katie Rezmirski for the.
Good afternoon, Your Honor. Jay Grant Miller, P 58658, on behalf of Mr. Riddle, who approaches the podium. Please state your name.
William Michael Riddle.
Thank you.
Notice court is aware this time and date scheduled for preliminary examination. The people are unable to proceed this afternoon.
Your Honor,
Go ahead.
in light of the people's position, we would move for dismissal without prejudice.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice. Right?
Thank you, Your Honor.
Thank you.
And Your Honor, Happy New Year to you and your staff. And I failed to say it the last time. I hope everybody had a very Merry Christmas.
Absolutely.
We were a
I
little
did.
more pressed last time for time. Thank you, Your Honor.
I did, because I stole all Alan's presents. So I had a great Christmas. All right. So the other one is a hold, and Ms. Willingham's not in. I'm gonna step off for a little bit and then come back, and I need this, pardon?
She's ready and available.
She is ready and available. Oh, okay, that's fine. I'm just gonna step off because I have to take a breath for a minute. And could I see you, counsel, back just really quickly? All right, court's in recess.
All right.
It's the best way to do that.
Gotcha.
Oh, I just.
My apologies about my delay. Where is,
I told him to go get his phone.
why don't we do this? Can counsel, does Weatherspoon, you have him?
He's going through security. He was right outside the courthouse door.
Okay, we'll wait on that. And Mr. Margolis and Swellingbring, can you approach, please?
Yes.
Court calls the case of People versus Terrence Weatherspoon.
And we told the defendant on behalf of people.
Assistant Public Defender Ben Dunaway on behalf of Mr. Witherspoon, who is approaching the podium now. And would you state your name for the record again, sir?
Terrence Weatherspoon.
Today's your lucky day. You're negative.
I told you, sir.
Huh?
I told you, I ain't you.
No, you didn't tell me.
You gave me a pass. Listen, though, you gave me a pass, sir. You,
Huh?
you reinstated my bond. I was in jail. Said I cannot be. I'm not gonna test dirty. I can't.
Well, we can indicate he's got a future in acting, so he is employable, Your Honor.
Okay, so he's waving up. Is that right?
He is, Your Honor.
All right, so sir, waiving your right to a preliminary examination.
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
And you understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
We do, Your Honor.
Preliminary examination hasn't been waived. Defendant's bound over on the single count.
And he did waive for the offer placed on the record 2 hours ago or whatever it was.
Yes.
Thank you, Your Honor.
Offer of use or possession, felony possession of controlled substance less than.
Yes.
And we will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for February 23rd, 2026, 1:30 before Judge Hamoud. Bond will continue. Mr. Weatherspoon, you may not think so, but I am so glad that it came out that way.
Me too.
I really, yeah, you're probably more so than I am, but I really am, because I'm just, all right, good luck to you, young man.
Thank you, Your Honor.
All right, so, yeah, wow. So, remember, court, we'll go into recess, because